Recording in progress.
Good morning, colleagues.
Kabaza. Chair.
Morning, morning. Does look like we do have a quorum. May we start if we're all ready? Looks like before we start, we've got Honorable Marina.
Good morning,
Honorable-
Chairperson. Good morning
Morning.
to the colleagues also online. Chairperson, I really want to make a plea with this committee and the departments that we do get our agendas well in advance of a meeting. Mondays are constituency days, number one, and also it's a heavy traveling day for us to get to Cape Town. I have to go from the Eastern Cape to the Free State to come to the Western Cape. So we received quite a lot of information yesterday, and it's quite unfair to have members of parliament go through agendas and documents less than 24 hours to a meeting. So I really want to plea with this department and yourself to make sure that those things come to us well in advance. Thank you.
Okay, may we start the meeting though? At this point, thank you very much, Honorable Marina. Well, just to constitute, let's just have a moment of silent prayer or meditation. Thank you, honorable members. May we then get the agenda reflected on the screen. The secretary, may we put the agenda on the screen? Honorable members, firstly, let me then say we welcome all the members. We'd like you to have a look at the agenda, and we take note of the concerns from the Honorable Van Zyl. It is a fair comment, and so we apologize for the delays and some of the late circulation of matters are also my fault, because I also asked some of the matters to be brought in. So I'd like us to have a look at the agenda, and then we can sift out what we might be having a problem with, and we might then decide whether we proceed with some of the things. Now, on the agenda, we have invited the department. Honorable Deputy Ministers are also present. I'm not sure if Minister is here, but Honorable Deputy Ministers are present, as well as the department. That was mainly because after being briefed by the Parliamentary Legal Services, I'd like to see if there's any additional information that might be with the department on the issue of the Traditional Khoisan and Leadership Act, so that they could actually bring in that aspect at that level. So then you've got the Oversight program. Then just assist me here again, Shireen, just on the issues here. Shireen, are you on the line?
Chairperson, good morning. Chairperson, good morning, members. Yes, I am on the line. We have circulated the resolution register with members. So we want to have a look at those resolutions and see if we want to program them for the next term, so that we do our program for the next term that can be submitted to the House Chairperson. And then that document, there's two documents, the resolution register as well as the constituency matters that members raise, so that we see what we do with those ones. before we close the term, Chairperson.
Thank you very much. What we'll do is, I will say, the issues that have been tabled, where we might feel that the issues are too much for us to deal with, maybe we need a bit more time, the members will just indicate that, then we can take them back. But I think we would have, tabled them for the members to reflect. But if then there's not enough information or not enough time, then we would then take the matters back. Can we have the members commenting on the agenda? Any amendments, any adoption, move for adoption?
I move for adoption, Chair.
Thank you. Any seconder? That's Honorable Mkalipi.
Good morning. I second the adoption of the agenda. Thank you.
Thank you very much. Okay, then we still keep the comment from Honorable Van Zyl about timely circulation of the documentation. So the Secretary, please take us through the first item.
Chairperson, the Parliamentary Legal Services will do the presentation. Thank you very much.
May we have the legal services taking us through?
Good morning, Chair, and good morning, members. I'm just putting on my camera so we can see who I am. My name is Michael Prince. I'm from Parliamentary Legal Services, as Shireen indicated, and I'm accompanied by my colleague, Lonwabo Sopela. I will be taking you through the presentation, Chair. Shireen, are you going to fly the presentation or can I share my screen?
Michael, you can share your screen. Thank you.
Is the presentation visible? Shireen?
It is visible.
Okay, thank you. Chair, today's presentation is a briefing about the Constitutional Court judgment of Mogale and others versus the Speaker of the National Assembly. And secondly, just some feedback to the committee about the consequent withdrawal by the Department of the Traditional Affairs General Amendment Bill of 2022. And that's just a restatement of what I just said, Chair, so I'll pass the slide. Just by way of background on the Mogale judgment, the Traditional and Khoisan Leadership Bill was introduced in the National Assembly on 21st September 2015. So from 2015 to 2019, Parliament and the provincial legislatures held public participation processes across all the provinces. The bill was passed by both houses of Parliament on the 26th of February 2019.
Sorry, Mr. Prince. Sorry, Mr. Prince, I'm very sorry. I'm sorry to interrupt you. I'm sorry, Mr. Prince, can you hear me?
Yes, I can hear you, Chair.
I'm sorry, just hold on for a second. I see that Honorable Deputy Minister has got his hand up. May I just invite Honorable Deputy Minister?
Sorry, thank you very much. Thank you very much, Honorable Chair and Honorable Members. I just wanted to register the apology of the Minister, that Minister Hlabisa is on an international trip as part of his duties as the Minister of Cooperative, and the acting minister, Minister Kubai, is unable to join because of the budget forum committee meeting, so which coincided with the portfolio committee. So I just wanted to register that their absence is because of those commitments. Thanks very much, Chair.
Thank you very much, Honorable the Deputy Minister. We welcome the apologies, but I must also say whilst we understand that they are not around, we did want to just ask the department and ministers just to be on standby in case at the end of this presentation there are issues that we might need to be brought to our attention. So we're not, kind of. It was not so obligatory for the minister to be present, and so we'll be present. Whilst we are present, we just hope that at the end you can just share the additional information. Honorable Mkalipi?
Yeah, good morning, Chair. But the Deputy Minister is out of order. The apology, he can't just wait until the presentation is finished or before the presentation. He has to stop the presentation in order to tell us about those apologies. This is out of order, Chair. Yeah, he's out of order.
No, my apologies as well. Look, I think the Deputy Minister...
My hand was up long ago.
The Deputy Minister needed to register the apology, which is a really courteous thing to do. My fault that I might have missed the hand earlier. So I'm sorry about that, but let's proceed. Thank you very much, honorable members. Please proceed, Mr. Prince.
Chair, I see there's another hand. Maybe I don't know if you just want to take that hand as well. It says DM Burns on my side.
No, that's the same hand now that I've recognized. Unfortunately, what happened here is that I reduced the screen and then I missed out some of the features, and that's how I missed it. But I'm back now. I'm aware that
no problem.
That happened earlier. Sorry.
Please
proceed. Sure, proceed, please. Thank you.
So just to start again, the bill was introduced, the Traditional and Khoisan Leadership Bill, in 2021, in 21st of September 2025. From that time till 2019, as I said, Parliament and the provincial legislatures held public participation processes in all of the provinces. The bill was then passed by both houses of Parliament on the 26th of February 2019. The President signed the bill into law as an act in November 2019. The act came into operation on the 1st of April 2021. Now, this act sought to address the shortcomings of the Traditional Leadership and Governance Framework Act of 2003. Upon the enactment of the Traditional and Khoisan Leadership Act, Ms. Constance Mukhali and Land Action Movement applied to the Constitutional Court challenging the constitutionality of the act on the basis that Parliament and the provincial legislatures failed to facilitate public involvement in the passing of the act. So in December 2021, the applicants applied to court for an order declaring that the National Assembly, the NCOP, and the provincial legislatures failed, as I said, in their constitutional obligation to facilitate reasonable public involvement in the passing of the act. The court held that the questions before the court were inter alia. 1, what are the standards prescribed by law for public participation? Secondly, did Parliament and the provincial legislatures meet those standards? And thirdly, if not, what is the appropriate remedy? In dealing with the obligation to facilitate public involvement, the court said that sections 59(1)(a), 72(1)(a), and 118(1)(a) of the Constitution obliges the NA, NCOP, and provincial legislatures respectively to facilitate public involvement in their respective processes. The court held that public participation is an important feature of participatory democracy and the lawmaking process, as it offers the public a meaningful opportunity to participate in the legislative process and to strengthen the legitimacy of legislation in the eyes of the public. The court also dealt with the standard of reasonableness, and here the court said that although Parliament has discretion to determine the manner in which to fulfill its obligation in terms of the Constitution, the process followed must be reasonable. The court thus held that in determining whether conduct has been reasonable in the context of public participation, the following three factors are important. Firstly, what Parliament itself has determined as reasonable and how it has decided it will facilitate public involvement. Secondly, the importance of the legislation and its impact on the public. And lastly, the time constraints on the passage of a particular bill and the potential expense. The court dealt with the first aspect, the level of public participation deemed reasonable by Parliament and the provincial legislatures. And here the court considered that Parliament and the legislatures have set out the level of public participation it deems reasonable in the public participation framework and the practical guide for members of provincial legislatures, members of Parliament and provincial legislatures. Some of the features of facilitating reasonable public participation in terms of these documents are as follows. Firstly, pre-hearing workshops must be held on the bill. Summaries of the bill must be translated in at least 3 languages spoken in a particular province. Invitations must be sent at least 5 weeks before public hearings, and provincial legislatures must give at least 7 days notice of a hearing, and permanent delegates to the NCOP on the relevant select committee must attend public hearings conducted by the provincial legislatures. These are the features that the court summarized out of those guides. In moving to the significance of the legislation, that factor, the court said that the Act replaced the traditional Leaders Governance Framework Act and aimed to address its shortcomings. According to the court, the parties agreed that the Act is a piece of legislation that is of major importance, impacting millions of South Africans, as it regulates one of the most controversial, complex areas of our society, namely traditional communities and traditional leadership. The court said that because of the controversial and complex subject matter that the Act dealt with, it required Parliament and the provincial legislatures to consult thoroughly and carefully with the public. In dealing with the last aspect, namely time constraints and expense, here the court said that there was no evidence that there was any pressure on Parliament to pass the bill within any particular time frame. The court further disregarded claims by some of the respondents that the cost of complying with the guidelines set for public participation was too prohibitive. The court held that government's reliance on limited resources must be supported by facts, and that the respondents did not provide any evidence that they were restricted by limited resources. The court considered the relationship between the NCOP and the provincial legislatures, and here the court stated that the obligation to facilitate public involvement rests independently on both the NCOP under Section 72 of the Constitution and the provincial legislatures under Section 118 of the Constitution. The court held as follows, and I quote, "It is important to note that the NCOP can fulfill its duty to facilitate public involvement through public hearings held by the provincial legislatures if those proceedings were attended by the members of the NCOP or members of the NCOP had access to the reports of those proceedings," end quote. The court stated that participation of permanent delegates or their access to the reports on public participation are significant for 2 reasons. Firstly, the NCOP plays an important role as a linking mechanism that acts simultaneously to involve the provinces in the national processes or purposes and to ensure the responsiveness of national government to provincial interests. Secondly, if the NCOP relies on provincial legislatures to facilitate public involvement, the NCOP must satisfy itself that the provincial legislatures hold public hearings that meet the constitutional standard. According to the court, the provincial hearings are part of the NCOP process, and any failings in the processes of the provincial hearings must be attributed to the NCOP. In dealing with the factor of assessing the public participation process, the court found that it was necessary to establish as a matter of fact what process was adopted by Parliament to facilitate public participation, and as a matter of law, whether that process that Parliament adopted was reasonable. Here the court considered the processes adopted by Parliament and stated as follows. The National Assembly, through the Portfolio Committee, invited written comments from a range of stakeholders, as well as held public hearings in all 9 provinces. The NA passed the bill and referred it to the NCOP. The NCOP, through the Select Committee, initially decided to hold its own public hearings on the bill, but later decided to defer the holding of public hearings to the provincial legislatures, whereafter the provincial legislatures conducted public hearings in all 9 provinces. The NCOP considered both the negotiating as well as the final mandates on the bill and adopted the bill with amendments. The NCOP thereafter referred the bill with amendments back to the NA. The NA adopted the bill as amended by the NCOP. The court found that in terms of both the NA and the provincial legislature's public hearings, there was insufficient notice given ahead of the hearings. The court stated that in many cases, in both the NA and the provincial legislatures, the notice period was far less than what was required, sometimes 1 or 2 days notice. The court states that the NA did not conduct pre-hearing education in various provinces, and in the provincial legislatures, there were no pre-hearing education in the Eastern Cape, KwaZulu-Natal, and the Western Cape. The court held that at various public hearings, either no or not enough copies of the bill were provided, and in many cases, the copies that were provided were not in a language that the local community could understand. The court highlighted instances in both the public hearings held by the NA as well as those held by the provincial legislatures where improper attention was given to certain groups to the exclusion of the other groups. The court stated that the Select Committee called for written submissions on the bill following the provincial legislature's public hearings. According to the court, the content of these submissions was insubstantially considered by the Select Committee in its final meetings before tabling of final mandates. The court stressed that it was particularly important that these reports present an accurate reflection of the public hearing process, as the NCOP deferred its responsibility to facilitate public hearings to the provincial legislatures and was requested to monitor this. Sorry, I suppose that should be, and was required to monitor this. My apologies. The court held that the NCOP did not consider or debate the substantive concerns in the negotiating mandates. According to the Constitutional Court, the deficiencies which occurred at various stages of the public participation process were numerous and material. The court therefore rejected Parliament's submissions to explain reasons for certain deficiencies. The court held as follows regarding the public participation processes. The court said that these deficiencies demonstrate a wide-ranging and substantial failure to facilitate public participation. Accordingly, the court held as follows, and what follows is the court order in the Mukhali judgment. Firstly, that Parliament failed to comply with its constitutional obligation to facilitate public involvement before passing the Act. Secondly, that the Act was consequently adopted in a manner that is inconsistent with the Constitution and therefore declared invalid. Thirdly, the order declaring the Act invalid is suspended for a period of 24 months to enable Parliament to reenact the statute in a manner that is consistent with the Constitution. Chair, turning now to the impact of the Mukhali judgment. So the court suspended the order of invalidity for a period of 24 months, as I stated, and that period expires on the 29th of May 2025. Should Parliament fail to address this invalidity, the Act would no longer be valid legislation on our statute book, and the situation before the enactment of the Act would come back into operation. In other words, the Traditional Leadership and Governance Framework Amendment Act and the National House of Traditional Leaders Act of 2009 will become operational again. Those are the acts that the act that was declared unconstitutional by the Mukhali judgment sought to repeal. So those acts will become operational again. Chair, moving quickly to the second aspect of the presentation, namely the Traditional Affairs Amendment Bill of 2022. On the 1st of June 2023, the then Minister of Cooperative Governance and Traditional Affairs withdrew the Traditional Affairs General Amendment Bill in terms of Rule 334 of the Rules of the National Assembly. The Minister stated that the amendment bill had sought to amend the Act, but having consequently considered the Constitutional Court judgment in the Mukhali case, the Minister wished to withdraw the amendment bill as the Act was adopted in a manner that was inconsistent with the Constitution and therefore declared invalid. Accordingly, the Minister stated that it was no longer necessary to proceed with the amendment bill, and she indicated that the matters contained in that bill would be dealt with as part of the process as directed by the court in the Mukhali matter. Chair, I just quickly want to move over to our recommendations for the committee. Firstly, just to state that the corresponding portfolio committee of the 6th Parliament agreed in discussions with the department at the time that the department will develop a bill to address this judgment. So as part of its oversight function, this portfolio committee can confirm with the department on the steps that the department has taken thus far to address the judgment. In the meantime, just some feedback. Our office regularly corresponds with departments on orders such as this. And this department confirmed on the 27th of June 2024 that the Office of the Chief State Law Advisor has provided the provisional certification of a draft bill to address the Mukhali judgment on the 22nd of December 2023, that the required socioeconomic impact assessment was signed off by the Presidency on the 22nd of February 2024, that the draft bill was presented to a technical working group of the Forum of Directors General in February 2024, and then at the request of the then leader of government business, it was not submitted to Cabinet in March of 2024, but held over to be submitted to the Cabinet once the 7th administration was established. Our office has again asked for progress in this regard on the 10th of September 2024. It is further recommended, Chair, that the committee through its oversight processes stress the need for Parliament to have sufficient time to consider the bill that will address the concerns of the Constitutional Court. Considering the parliamentary calendar, there are just over 6 months left for both houses to consider and pass legislation before the 29th of May 2025. Chair, that brings us to the end of my presentation. Thank you.
Thank you very much, Mr. Prince. I think the latter aspect about your communication with the department is also helpful. Honorable members, would you mind if we were to ask the department to make any additions onto this subject, particularly considering that they've been having some progress on this, on the processing of this bill? Could we invite someone from the department to give us through? Do the members have any challenge with that? Can we proceed to do that?
We would welcome that, Chair.
Thank you. Thank you very much. Let me ask the Deputy Minister and the DG if we've got any notes to add on top of what has been tabled. We'll give you about 10-15 minutes to take us through if there's anything that you'd like to take us through. Honorable the Deputy Minister.
Thank you very much, Honorable Chairperson and honorable members of the committee, colleagues in the department. Firstly, Honorable Chair, let us also welcome the presentation by Mr. Prince. There is certainly mutuality in terms of our appreciation of the process. Safe to make reference to the following one. In terms of the National House Splitters Act, which was subsequently repealed as a result of the enactment of TICLA. I think it was section 18, if I'm not making a mistake. DG, you will correct it. There's a specific clause on the referral of bills to the National House of Traditional Leaders. And the referral of bills to the National House of Traditional Leaders is not just an exercise, or by the way exercise. It's a statutory, it poses a statutory obligation First, on the part of Parliament to refer the bills, but also on the part of the National House of Traditional Leaders to also conduct its own engagements and or public hearings, if you were to put it that way, within its own constituencies as a representative body, so that when it consolidates its own submissions, which would have dealt with the bill in terms of clause by clause analysis and reflect on anything that would have been identified as probably needing specific attention by Parliament or by NA or NCOP, whichever, then with those kind of comments, then they are able to say, from the views that we have solicited from various provinces, which would have been canvassed from different traditional communities, these are the issues that, as houses of traditional leaders, we expect the bill to reform. It looks like Parliament, when it refers bills to the National House of Traditional Leaders, it simply refers the bills as part of the procedure without paying attention to the important role that is played by public participation in the course of referring those bills. So my sense is that if we can tighten the kind of complementarity between Parliament and the National House of Traditional Leaders, to the extent that it talks to the issue of referral of bills and the consequence of strengthening public participation, that should actually strengthen the importance of what the court has spoken to. I think that element is very critical to reflect on. And the other aspect, it relates to the General Amendment Act, which would have covered other substantive issues which Parliament, which court would not have applied its mind to, which I suspect when as part of this process we conduct public hearings, those issues will be raised. Especially when we deal with matters of the Khoisan communities in terms of the categories of traditional leadership positions, when we deal with the issue of the participation of traditional leaders in terms of Section 81 of the Municipal Structures Act, and perhaps what we should be dealing with as a transitional measure for the participation of the Khoisan communities in the current dispensation before their formal recognition that would have been validated by the Khoisan Commission, as well as concerns that have always been raised by both kings and headmen in terms of the representation in the houses. So these substantive issues would have been covered by the General Amendment Act. Now, we should also be alive to those issues, and as part of the processes that would be led by committee and parliament, we proactively deal with them so as to ensure that by the time we pass this bill, we pass it as a bill that is watertight, that will certainly pass the constitutional muster. I think those will be the reflections I make, Chair. Thanks very much.
Thank you very much, DM. May we ask the DG to come in?
Thank you very much, Honorable Chairperson, honorable members of the committee, Honorable Deputy Minister. We are in full agreement, Honorable Chair, with the presentation as made by Parliamentary Legal Services. It's indeed in line with how the process has unfolded. Perhaps just to add that in terms of the last update we shared with them, we indicated that the matter has now been tabled before Cabinet. It was tabled before the Cabinet Committee this past week, and the expectation is that then the Cabinet Committee will make its recommendations to Cabinet for a decision. And then we will know after that decision from Cabinet whether approval has been granted by the Executive to introduce the bill in Parliament. And then the rest of the processes will indeed follow. So I think just to add that this has been tabled before Cabinet already. Perhaps just to confirm in terms of the point the Honourable Deputy Minister is raising about referrals of bills to the National House, that indeed it is provided for in terms of Section 39 of this Act, the Traditional and Khoisan Leadership Act, that parliamentary bills that directly affects the traditional and Khoisan communities, or which pertain to customary law or customs of traditional and Khoisan communities, or which relates to matters that are contained in Section 1542 of the Constitution, which is matters relating to the functioning of local government, that they should be referred by the Secretary of Parliament. They should be referred to the National House. What this Act does, which was not there previously in the Framework Act, was to even specify the amount of time the House has to deal with a bill that has been referred to them. So this Act specifies that the House must, within 60 days from the date of such a referral, make comments it wishes to make and submit them to the Secretary of Parliament. So it is expected that once this bill has been tabled in Parliament, the Secretary of Parliament will indeed, in terms of Section 39 of the Traditional and Khoisan Leadership Act, refer the bill to the National House for comments as well. But other than that, we just confirm that we are in full alignment with the presentation as made by the Parliamentary Legal Services. Thank you very much, Chairperson.
Thank you very much, DG. Before the members start asking questions, are you satisfied that this bill will be with Parliament in time to be processed through to meet the deadline? Because we would be concerned that we are stuck with a bill that we haven't got adequate time, but it's dragging over the different offices in the department, in the cabinet, and it's taking so much time that by the time it gets to Parliament, there is not enough time. Are you satisfied that will meet the timeline in terms of the processing of this bill? DG?
Thank you very much once again, Honourable Chair. It's difficult to say in terms of the parliamentary processes that will follow, because I think looking at the time that is left, it means that Parliament would have more or less 5 months after the bill was introduced in Parliament to meet the stipulated requirements of public participation. So it will really depend on the process map that Parliament comes up with. But I think I should just add that if at any stage the assessment is that the period will not be adequate, we have been advised by senior counsel that the Constitutional Court may be approached on time to indicate that because of the following reasons, we would need additional time to fully satisfy the requirements of the Concord judgment in terms of adequate participation. This is how far we have been able to go, but because of the following reasons that could include, for example, the interruptions arising from the election period, as indicated in the presentation. There was a time where in March we couldn't proceed with introducing this to Parliament because of the intervention, quite correctly so, by the leader of government business, that let's now allow the space for closure and rounding off of the work of the sixth administration. So those could be among the reasons that get advanced, but also just because of what the Constitutional Court itself raised around the steps that must be taken by Parliament in terms of the public participation process. So I think in part, Honourable Chair, I think it will depend on the process map that Parliament comes up with. But there is this proviso as well that if the process map suggests that maybe a few more months will be required, we have been duly advised by senior counsel that the Constitutional Court may be approached to seek indulgence so that there can be an extension to conclude the public participation processes. Thank you very much, Honourable Chair.
Okay, this other next question, I'd like either both department and the parliamentary legal services to just guide. Firstly, in the event that there's such a delay, and this is my own ignorance, who is responsible for approaching the court to get the extension to be condoned? That's the first question. The second question is that in this process, there are two primary issues that are involved here. One is a technical processing of the bill, which is the public hearings, which is where the fault was as raised by Parliament, as raised by the Constitutional Court. Now, that's the one aspect. There's a second aspect here of what appears to be the defects in the legislation that would have required an amendment to be effected. Now, the question I have is, we can cure the issue of the consultation quite easily, but then the question of the amendment, would that be in the hands of the department? Otherwise, is the bill coming here already amended with amendments, or this process of amendment is something that we might have to consider whilst the bill is being processed within Parliament? And so I'm more interested in the proposed amendments that the department already had before that they couldn't proceed with. So I just need to understand between the two, arms, which would have to be responsible for dealing with this amendment, or what would be the status of that. After that, I'm going to ask the members to come in and make comments. And here, I'd like both the Parliament and the department to just give us their own reflections on the matter. Thank you. DG first, and then we'll come to the parliamentary team.
Thank you very much once again, Honourable Chair. I think the legal services of Parliament will come in as well, Honourable Chair, as you've indicated, because the judgment was primarily the ruling was primarily in terms of cabinet, parliamentary processes, not processes of the executive. That's why I think, even in terms of opposing the application in court, it was by and large the legislators that did that. Of course, some of them didn't, but Certainly the National Assembly did that, and some of the provincial legislatures as well opposed. The executive joined as well because you're aware of what would be the implication of the judgment on the work of government. So I think it would really be important, in my view, if Parliament takes the lead. But I because we are an interested party as well, I believe it's a matter that can be done together with the executive to approach the Constitutional Court. I think that would be important because there are certain questions perhaps that can only be answered by the executive to say what happened after the judgment was done. Why is it that perhaps the bill was only introduced in Parliament, for argument's sake, in September or October 2024? Parliament may not be able to provide responses to those issues. So that would be my view, Honourable Chairperson, that it's something that in my view, Parliament should lead, but supported by the executive. On the second issue of amendments, at this stage, the bill does not come to Parliament with any amendments, because our concern was that if we introduce amendments at this stage, then the bill would require other processes at the level of the executive processes of participation and public participation, for example, at the level of the executive before it's tabled in Parliament. And given the time pressures that we're working against, it was not going to be possible to do that. So there are no amendments that have been introduced. What has been introduced in the current version are really what we call technical amendments. So, for example, we had to change dates where the TKLA would have referred to 2022 as the particular period of the term of office of the National House. We had to change that and make it 2027. We had to introduce new definitions, for example, such as date of invalidity, because the issue of the date of invalidity arises out of the court judgment itself. We had to introduce transitional measures as well, which means what happens to the decisions that were made in terms of the TKLA before invalidation. What happens to those decisions once this new piece of legislation comes into operation? So those are technical amendments, really, as opposed to substantive amendments. So they have not been introduced in the current version. Our view, Honourable Chair, is that once the public participation process begins, that now becomes the opportunity for all stakeholders who want to propose amendments to make those amendments available to the committee as it runs this process. So they can't be introduced by the executive at this stage, but they have to be introduced by, as part of the public participation process of Parliament. And that is only out of that process that the amendments then can be considered. And to the extent that there might be those that the executive might want to propose, it means that will also have to come through as part of the parliamentary process. That is my understanding, Honourable Chairperson. Thank you.
Thank you very much, honourable members. I omitted to introduce the whole delegation of the of Parliament, of the legal services, parliamentary legal services. There's Miss Resida Bag, Division Manager, Core Business, and then there's Mr. Brent Simons, Content and Information Manager, Parliamentary Communication Services. Then there's Advocate Charmaine van der Merwe, Senior Parliamentary Legal Advisor. There's Michael Prince, Parliamentary Legal Advisor. That's the one who did the presentation. Then there's Lonwabo Sopela, Parliamentary Legal Advisor. So Lonwabo Sopela has got his hands up. So I would like that he makes the comment at this point. I have noted the Honourable DM, Honourable Van Zyl. I'll follow after that. After the parliamentary legal team has commented, I'm going to be requesting all members to start making their comments on this matter. So let's start with Mr. Lonwabo Sopela, and then we'll follow with the DM. Thank you very much, Mr. Sopela. Please proceed.
Thank you, Honorable Chairperson, and good morning to the honorable members. I was just showing the face temporarily. I will now stop the video. The DG, Honorable Chair, has responded, I think, sufficiently when it comes to the matter of the amendments. To just say we agree that it is just a bill in the same manner as the act that has since been found to be unconstitutional. And obviously, we always say this, that sometimes the challenge on public participation is usually because there is someone out there who is not necessarily happy about the contents of the actual bill, and therefore they attack on that basis. And I think we raised as much on the presentation as well. I will just round off on the issue of the extension, Chair, which you asked as the first question, to say there is usually a discussion between the concerned department and Parliament as to who must apply for extension. And in circumstances like this one, we will just have to have a meeting maybe with the department to say who must apply for this particular extension. But I do not say that Parliament will have a problem, except that it also gets to have costs, and as at this stage, for example, the bill is still not before Parliament when, as of June last year, that is the time when the judgment was issued. So it's something that would be discussed, but Parliament has, in many instances, and even recently, there's a matter of the Women's Legal Resources Center, where Parliament went earlier this year to the Constitutional Court to seek an extension because it was not going to be able to meet the deadline of 29 June 2024. And we sought an extension, and we were granted an extension until 28th of June 2026. So I'm saying it is something that can be handled, but we will just need a meeting of both parties so that also those that are senior in Parliament are able to be part of that decision, and the DG is also on his part able to be part of that decision on how that process of the extension is going to be handled. I think let me leave it there, Chair. Thank you.
Thank you very much, Mr. Sopela. Honorable members, would like to invite your comments. Let's start, Deputy Minister, then Honorable Van Zyl.
Thanks very much, Honorable Chair, and honorable members. I think my input, Chair, would have been part of what DG, it's in addition to what the DG said, because there's something that we should also be alive to, that the bill we're talking about touches the nub of Section 154, subsection 2 of the Constitution, read, of course, with Section 212 of the Constitution. In that, one, it's a constitutional pre-requirement that the draft legislation, in this case the bill, which would affect the status, institutions, powers, and functions of local government, must be published for public comment. And when you publish that, it should be done in a manner that will allow organized local government, municipalities, and interested parties an opportunity to make representations. So you'll find that if we talk about this bill, it does relate to local government. And also when you read section 212 regarding the role of traditional leadership, the space at which it operates. So this requirement, it means it must be done before it is introduced to Parliament. So we'll have to factor that in as part of the processes that must ensure that when we are at the stage of cabinet tabling the bill before Parliament, such processes must have been complied with. That's the point I wanted to bring to the equation, Chair, in ensuring that we bring a watertight process going forward. Thanks, Chair.
Thank you very much, Honorable Deputy Minister. I have a number of hands now, so we'll follow this order. Honorable Marina van Zyl, Honorable Labuskaghni, Honorable Ndamase, Honorable Taibosh, Honorable Sols, Honorable Mkalipi, Honorable Reddy. That's the order we'll follow. So may we open for members to comment. Honorable van Zyl.
Thank you, Chair. Well, my question really would be around the costs. I'm very interested to know what the total cost to Parliament was. That includes, officials having to go to these various public participations, members of Parliament, their S&Ts, whatever the case may be, the travel. I'd like to know how much did this cost Parliament before the Constitutional Court matter, because now we have to go on a second round. And it's not failures of anything else but Parliament. Because if you heard what these legal advisor had said, that it's copies not printed, it's advertisement not done effectively and efficiently, it's language is not correctly, it's the people not explaining 2 weeks in advance what the bill was about. Those are all failings of Parliament. So that's my first question. And the second question that follows onto that is to say that what consequence management will there be? Because obviously we cannot, there's not a bottomless pit of money that you can just tap into to, have public participation, go to Constitutional Court and having to do it again. So there must be some sort of consequence management. So I'd like to know the department's plan or Parliament's plan really on that. Thanks, Chair.
Thank you, Honorable van Zyl. Honorable Deputy Minister, please take down your hand so that we can recognize when you want to come back. Honorable Labuskaghni, you're the next.
Thank you very much, Chair. Good morning, everyone. Chair, yes, I would like to know, given the fact that the court gave us a time and that Parliament asked for extended time, and that time is now June 2026. We are in September 2024. And if I look at what has been set out, that this will now first have to be published for the input according to Section 154, which is correct, for the input from local government and everyone, and have to go through the whole process again. I would like us to have a clear timeline, because I've been in the NCOP when this bill was there. I would also like to know, when I remember that a lot of things were raised about this bill, specifically from not only one party, but more than one party. Very often in the process of lawmaking, which in the parliamentary part of it, we are supposed to make sure that we make good laws. But unfortunately, we all are members of political party. And sometimes politics play a bigger role in the process of lawmaking than the law itself. And
Recording stopped.
I tend to think that this was the case with this specific piece of legislation, unfortunately. So I would also request us not to fall in that trap again. But the one thing that I really think we need to sit down and say, as the committee, because we are the lawmakers now. At the moment the bill is not in Parliament, but I would also request that Cabinet looks at this bill and see that the time frame is very short, with everything in between, so that we can have a specific time frame of when is what going to do, who is going to do what, when will this bill be published for public comment, when will it be ready to come to Parliament, because we cannot run into something again that Parliament is not going to fulfill its role, and again this bill can be tackled court. Thank you.
Honorable Labuskaghni, very interesting. You should raise those issues for two reasons. Firstly, the people who opposed the bill and took it to Constitutional Court, my sense is that they may not have only been dealing with it from the point of view of the timelines or from the consultation, the process. They may be having substantive issues that they have against the bill. So politics may be inevitable, but I think it's good you raise that, because the issue is we need to know what should we focus on as the committee. Members will comment. The other aspect is that I'm not sure how we will avoid delays and the need for extension if just the process of consultation has to be thorough, but also we envisage bringing in certain amendments. So anyway, I'm just saying, you making those comments, we need to be alive to what we're facing. Honorable Taibosh, you next on the line. Thank you.
Thank you, Chair. Good morning, honorable members, honorable Chair, honorable Deputy Minister, and the officials. Thank you, welcome. Honorable Chair, yeah, this bill should, in the first place, never have been passed. This bill was passed in November 2019 under a cloud. It was a tick box exercise to pass this bill. This bill does not address what the Khoisan people are. Firstly, how can you refer the bill to the National House of Traditional Khoisan Leadership, all right, for them to pass the amendments? I don't think those people are suitably qualified to do that. Firstly, they came up with a bill that says that there are no Khoisan kings and queens and chiefs, that there are only headmen and senior headmen. So, firstly, who qualifies that decision? Who made such a decision? Is my first question. The fact that the Khoi and the San leaders cannot be members of the National House of Traditional Khoi and San Leadership, all right, it creates a further problem for me, because we are not recognized, we cannot be members of that body, all right? And this same document will go to the NHTKL again for them to officially recognize it, without the presence of the people that it probably affects the Khoi and the San people the most. Remember, this bill was only introduced mainly to give recognition to the Khoi and the San leaders. So the NHTKL leadership like they told Minister Mackenzie the other day that we're fighting, we're arguing always, and that's why we're not members. Instead of telling the truth that we are not members because we are not recognized officially by the government. Okay, so that maybe Minister Mackenzie would have had a better idea as to, why he's calling this meeting and why are we not recognized. It's for us to go back to the bill. The amendments to the bill, all right? We have so many submissions of amendments to the bill, but none of those amendments were recognized. They stuck to their guns from the first time they tried to introduce the bill. None of the amendments, I've got amendments that was done by an advocate on my behalf, that was overlooked, completely overlooked, all right? The thing is they had to rush this bill to get it through so that they could tick the box before they go to the United Nations. And if, just on Honorable Van Zyl, it's going to cost them a lot more money. Again, they are not doing it properly. They are not doing the right thing with this bill. And the Khoisan descent is here now. We are, hopefully we'll get an opportunity whilst we in the portfolio committee and in the National Assembly to speak about this bill. Hopefully we'll get an opportunity to talk about the shortcomings of this bill, the amendments to this bill, because you're very right, Chair, when you say that the Mohale people, when they registered the case with the Constitutional Court, it was just not a matter of insufficient public participation. It was the content of the bill that we were not happy with. This is the old Bantustan bill that was tweaked to include the Khoi and the San so that they don't have to go to the Constitution and make a constitutional amendment to recognize the Khoi and the San officially. That's why this bill came about. So until we go back and recognize the Khoi and the San in the Constitution, this bill, as far as I'm concerned, will fight it and it will never see the light of day again ever. Thank you, Chair.
Thank you, Honorable Taiposh. You're gonna have to help us through the process because we can't stop this process and go and start amending the Constitution. So we need to discuss how best we can address the issues. And of course, let's flag the issue of constitutional amendment as a separate matter. So I would like us to focus on what of these amendments are possible to bring in here and discuss. That's why I'm saying to Honorable Labuschagne that I think it's inevitable that we will overshoot our timeline with this thing. But that's by the way. Let's come back to say our responsibility as Parliament is to amend this bill. And your point and your contribution is about what was missing that needs to be brought in. And the process allows us space to introduce amendments where we believe we need to. And again, looking at them outside party political eyes, just looking at sorting out the communities of South Africa. And so I think that's the attitude we have. But the issue of the constitutional amendment becomes a separate issue. So we don't overlay it on top of this one. Let's talk about it, because otherwise, if we were to take your point to its final conclusion, we would then be saying, stop the bill, let's go for constitutional amendments, thereafter come back to the bill. Now, that may not be able to work. I'm just saying, think about it.
I hear you.
I'll give you a chance to come back.
Okay, thanks, Chair.
Yeah, you'll come back.
All right.
Yes?
I hear you, and I agree with you. I think taking it to constitutional amendment and stuff like that, it's another process. But Chair, this bill was rejected by 99% of Khoi and San leaders from the word go. This bill does not address the needs, the Khoi and the recognition of the Khoi and the San people. This bill subjects us to a process which not everybody that is recognized today was subjected to, first and foremost. This bill decides for us, what we were found here, Chair. We were living a certain way, a certain way. Now we are prescribed to by people that came and find us on our land, our motherland. If we didn't save this country, this South Africa, for everybody to live in it now, there would have been nothing. Instead of giving us the recognition that we should get, proper recognition, they tell us, hold on, oh, sorry guys, because you are so little, we can't give you chieftaincies, we can't give you kings, we can't give you queens. How do they qualify that? That's just part of it.
Okay, listen, look, let's leave this, because if you go that route, you're going to lose each other. Look, the point at the end of the day is that we all Africans here, we are members of this society, this is our land, we all part. Now, where I agree with you is only one thing. It shouldn't have happened that the Khoi and the San people should have been left out of the original structure of the bill. That I think we agree. And on that basis, that was recognized and that's why it was corrected. So I agree with that. I don't think we're going to, who was here before who and all of that. We're not even going to who fought who did what and all of that. We're not there. Where we are is that we are here. We all belong here. But at the end, we are agreeing also that this bill needs to be amended to ensure that the excluded communities are included. You got 100% support for that. Then the issue is how, and that's where we need to be focusing. But
that's
we will
what
come
I
back.
want, Chairperson.
You'll come back.
Go back to how. That's sufficient enough. I'm not saying that we want to change everything. I'm not saying that, and I'm not being unreasonable when I say that we can't also just be.
Chair, may I get in, please? May I get in?
Yeah. Yes.
Please, I'm just making a humble plea to Honorable. Let's not make a dialogue. He presented his view. Can we please just give others a chance to speak? Then, because now it's like it's becoming a dialogue. It's not now. We are not discussing the matter. We understand how emotional, how he is. He's in touch with that process. I know him very well. So I'm making just a humble plea that can he please just humble himself and then give us a chance also maybe to make some inputs. Let's just debate about this matter.
Yeah.
Thank you.
You're quite correct, Honorable Sompa. Honorable Typewash, you'll come back. Let's leave the other members to come in. I'll recognize you again. Let's move on. Honorable Sols.
Thank you, Chairperson, and greetings, Deputy Minister and the Parliamentary legal team and the honorable members.
Sorry, Chair, was it not Ndamase?
Honorable Ndamase, you lowered your hand, so you fell off, out of sight, out of mind. Can I get you soon after Honorable Isaacs? Please, sorry, it was supposed to be Honorable Ndamase. But when the hand was lowered, I missed it. But the Honorable Sols has started. I'll get you just after that, if you don't mind.
Okay, Chair, okay.
So sorry about that, but just for understanding the technology, don't lower your hand until you are done. Otherwise, I think you have reconsidered your position. Thank you.
I'm okay for Honorable Ndamase.
Chair, I did not lower the hand, Chair.
All right.
I did not lower the hand.
All right, I can't see the hand. That's what I mean then. But that's fine. Let's go back. All right. Honorable Sols is prepared to stand down for a while. Honorable Ndamase, come in, but I still can't see your hand. I saw it at the beginning. Let's just check our technology gadget if they are okay. But your hand has fallen off, but I recognize you now. We'll come back to Honorable Sols. Thank you, Honorable Sols, for that.
Thank you very much, Chair. Greetings to the meeting. My apologies, I will not be able to show my face. And the first point, Chair, I would plead to you is that if there are follow-ups, let those follow-ups come at a later stage. And it becomes problematic if I can speak and then finish. And then just in the middle of an engagement, I have to come back without being recognized for any follow-ups. Apart from that, Chair, I have the following to comment on, and I'm happy that I will not be discussing this matter from a legal point of view. I will be discussing it from an aspirant Marxist-Leninist point of view. One, Chair, I would like the representatives from the parliament to come clear here. We can't second guess whose responsibility it is as late as now. I was listening to Mr. Sopela and has given an impression to me that there are still going to be discussions between Parliament as well as the department in relation to any application that might arise for an extension, which I differ. To me, Parliament must take responsibility here. Not because I say so, must take responsibility because if we have been found wanting, it is Parliament that has been found wanting. And I was listening to the DG. The DG was trying very hard to be nice. I'm not saying it nicely, but I'm saying it as a fact that out of the facts that have been presented into this meeting is that parliamentary processes have been found wanting. And therefore, the accountability resides on the Parliament. And therefore, Parliament must understand that and be able to articulate it. Because if they don't, they might again fall into the same trap. Because if there is a problematic in relation to an issue that has to do with public involvement, then Parliament has to stand up and say, we were found wanting there. If it has to do with the law making, go to the Constitution. The Constitution is going to tell you whose responsibility it is to make laws. So that must be clear. I can only sympathize with Parliament as far as the seniority of the officials that are in this meeting. The advantage for the department is that the accounting officer of the department is here, and the accounting officer of Parliament is not here. I'm not saying he was supposed to be here, but I'm saying the delegated officials that are here, they must understand that there is a process that must be made clear and be done effectively by the Parliament, because we're in this challenge now because Parliament did not do its work. It's Parliament's work to reproduce copies, to go get interpretations, to look into the language, to do public education. That is not the responsibility of the department. Can that be clear, Chair? Unless there is another argument, because all these very, very flimsy things that were not done by Parliament. And the Parliament must understand that and be able to demonstrate that they are not again going to fall foul of the same. I'm saying they are flimsy. They are really flimsy. If you cannot be able to produce photocopies, if you cannot conduct public education, what else can you do? Because there is nothing technical about that. So they must be able to say it in this meeting if they are really ready to be able to rise to the occasion, so that we do not come back and then argue the issue of costs. For that matter, democracy is very expensive. And so we must forget those shop if we think we're not going to spend. And the reason perhaps that they thought they did not have money when they did not do what they were supposed to do before, that's the reason we're here now. We have to spend another money because of their own failures. Now, the officials that are here are officials that I suppose that they are delegated by the accounting officer to be able to take decisions. If they can't take those decisions, they must have a way of communicating with the accounting authority so that we don't go back to the same thing. That's point number one. And Now, can we ever be certain that we're going to have a watertight bill, Deputy Minister Chow? I don't know. And I cannot even guarantee it myself, because I know for a fact that there are issues that the traditional institution has, not perhaps against the very bill, the act that we're talking about, but of course also directly as they affect the constitution. We have been asked about the chapter 12 of the constitution when we interact with the traditional institutions, and they have a very big issue there, and that's the constitution. And those issues, they will continue raising them when we're in the process of the lawmaking. At any rate, when they find a gap to be able to raise those constitutional issues they have problem with, we may not be able to win in terms of trying to shut them up. I sympathize with Chawe as a deputy minister, because Chawe is a deputy minister. He is not a traditional leader. That's the responsibility that he holds in his capacity as the deputy minister. And therefore, the traditional leaders down there, whether it has to do with Nklap, they are looking up to him as his representative. And I know that he is going to face other things in relation to all the other issues. And my argument is that the traditional institution itself, it is a political institution. So there is no way that we're going to be able to remove politics from it. Of course, other political parties, they have aligned themselves with all, I don't know how do we put it in English, but abantu ababanga. If you recruit abantu who aspire to be traditional leaders, they will be able to have a kind of a slant that they are going to follow, because ukwapo babanga khona, and they have hopes that is not resolved izinto zabo through this kind of an arrangement. And we cannot run away from those realities. My last point, Chair. My last point is that when we are also engaging in the same process of lawmaking, we must also know that there may be a regulatory process that would follow the lawmaking process. We might not be able to resolve everything when we enact any legislation. But we hope that, and I would advise the executive arm also to cast its own eyes on the regulatory process that they are going to do in order to try and ameliorate some kind of gaps that are going to arise as we continue with the process. Thank you very much, Chair.
Thank you very much, Honorable Ndamase. Firstly, let me say, because I want the other members to comment on this, the issue of who leads in responsibility. I think if we look at the court papers, there are 16 respondents. Respondent number 12 is Khoisan Minister. Respondent number 14 is the President of South Africa. The rest are all Parliament. It's the first respondent is Speaker, and the rest of them in National House, and then the rest of them are provincial houses or provincial legislatures. So the issue is around the speakers, the issue is around the Parliament. So I think maybe we need to just formulate our own view on this matter as a committee, so that there's no doubt about who we expect to lead as such. So that point that the honorable member has just raised, so we can comment on that as well. Honorable Sols, let's have you as your next speaker.
Thank you, Chair, and greetings once again to everyone. I think just as a contribution or input first on my view on the process thus far. Of course, there has been certain dissatisfactions raised, but I think we can find joy in the fact that our constitutional process is working, because we are at this point now because the court has found that the constitutional process of public participation has not been adequately satisfied, and now therefore presents another opportunity for there to be robust engagement and broad participation. And I think through this process, we will be able to raise all the concerns and issues with the particular bill. Therefore, I would urge the committee and everyone that is part of this meeting and everyone involved to sort of be sensitive to the importance of this particular process, and that we are intentional about ensuring that this process is done properly, so that we are not found wanting. I think that's the first contribution I want to make, but I am very excited and happy that it's going back to public participation, and this provides an opportunity for us to ensure that it is done correctly, that everything that is needed to be represented in the bill is done and is represented. But what is going to be key is our function to ensure that it's done within the proper timeframes as the court has directed. With that said, Chairperson, I want to ask Mr. Prince. He said that on the 10th of September, they asked for progress, but in the presentation does not indicate whether such reply formally has been given. So I just want to know from him, after the inquiry on progress on the 10th of September, was there a formal reply, and what was that reply? Then lastly, Chair, for this meeting, I heard on the meeting that the recording of the meeting has stopped. I just want to know, was that intentional, and why is the meeting no longer recorded? Thank you, Chair.
Recording in progress.
Well, there's your response. I wanted to ask the same question myself. Thank you. I hope that there was no part of this meeting that is not recorded. And please, we need this properly recorded. So let's not get back to this issue ever again. Honorable Mkalipi, you are next speaker. Honorable Mkalipi. Honorable Mkalipi. All right, we'll come back to Honorable Mkalipi. Let's get Honorable ready.
Honorable Chairperson, honorable members of the committee, the Director General, and the team present, let me begin by firstly thanking you for the invitation, especially for your engagement regarding the Traditional and Khoisan Leave Act. As a representative of Umkhonto we Sizwe, I need to make it very clear that we do not just the interests of the Khoisan people, but all African people in the country. And I think it's important that I place this on record, that as a party, we would fight any injustice or anything that we see to be unfair to any particular group. I must, however, address, Chairperson, the ongoing delays in finalizing this crucial act. These delays, as was pointed out by an honorable member right at the start, the member from the DA, I think, lie squarely with Parliament. And someone must be held accountable for this wastage of time resources. It is totally unacceptable, Honorable Chairperson, that we continue to delay the recognition and the empowerment of the Khoisan leadership, who have been historically marginalized and they've been overlooked for far too long. We are now being asked for more time, as if this matter is not of critical importance. This delay, it sends a very troubling message It says that the voices of the Khoisan people and their leadership are not being given the priority it deserves. Parliament's inability to finalize the process totally undermines the very principles of justice and equality that we claim to uphold. We cannot allow this, Chairperson, to continue. What is being done about this? We demand as a committee, we want some answers. We need clarity on why these delays and immediate steps are being taken to ensure that the Traditional and Leadership Act is finalized without further procrastination. I want to pause there and mention that my colleague, Honorable Taibosh, he is a leader within the Khoisan community, and I appreciate your approach, Chairperson, in allowing him to be a part of the process where his views and his knowledge and his history in the struggle will be able to play a very pertinent role in finalizing this issue. I get very worried when he makes statements that the bill itself does not address the real concerns of the Khoisan people. I get very worried about that, and I think all of us as members of this committee should be as well, because there's no one among us here that is close to the issue of the Khoisan people as Honorable Taibosh is. So I'm glad that you said that we will engage with him further and allow him to also make input in the process. Thank you very much, Chairperson.
Okay, thank you very much. Honorable Taibosh will come in afterwards. We'll still allow Honorable Mkhalipi, but let me say, Honorable Reddy, when Honorable Taibosh says that this bill does not address all the concerns of the Khoi and the San people, this bill, even when we are done with it, it will not address them all. There's no way it can. He has tabled to me a number of issues, and I've circulated the letter to the members about the issues. A number of those issues in terms of the governmental bureaucratic processes don't fall within the realm of what COCTA should be dealing with. We're only dealing with the leadership structures of traditional leaders. There are a number of issues that are part of the debate, which are relevant in this discussion, but not relevant for the law, the legislation that we are trying to table. As a result, we will need to take those issues up as a matter of recognition of the need to correct certain injustices to other committees. And in this case, we did talk about this. So I think when we start, our expectations need to be about what is within the scope of this committee to do, and of course, what is in the scope of a democracy to address. Those are two things. So I don't think we must assume that all the issues will be addressed by this bill, but there are issues that we must support, even though they don't have to do with this much to do with this committee. So we will come back. That's why I said Honorable Taibosh will come in again. We can talk about those, but some of the issues, when we talk about them, won't find their way into the bill. So we must understand that early, although there are issues that are outside the bill that are not in the bill, that we will find a way to introduce as the amendment, as the bill process is going through. It's important for us to understand that as a matter of approach, so that as a committee, we should be aware that this we will introduce, this needs to be referred somewhere else. Honorable Mkhalipi, you are next, and after that, Honorable Sompa will be the next. Honorable Mkhalipi.
Usaye shop.
She must buy another computer.
Chair.
Hello, come in. Yes, Honorable Mkhalipi.
Okay, no, Chair, I think I have a problem of a network. I lost you for a while you were just engaging in terms of the bill itself. Chair, I think I'm partly covered by the previous members on the issue of the delay, because that must be also be noted by the committee that we are very worried about the delays in order to ensure that this bill is amended in time. When I was listening to the DG, he was saying that because I think the first member who asked or engaged in this issue asked about what will be the consequences if we don't meet the deadline that was issued by the Constitutional Court. And if I remember very well, or if I capture very well what the DG was saying, he was saying that we need to go and approach the Constitutional Court in order for us as Parliament to be given as extension. That is very worrisome, Chair. Maybe let me just also share with members that on the strategic plan of the Parliament that took place last week on Thursday, this issue of the delays in terms of the bills was also a very big issue. And now the thing that is also been very clear is that there is no capacity in the legal office of Parliament. So it's not about only this bill, it's only this bill that is being dealt with in the committee. But if you check all the other bills that are delayed in terms of processing in Parliament, it's because of that legal office, because of incapacity. I agree 100% on what Babunda Mase was articulating here. There is also a very big problem, the gap, in fact, between Parliament and the executive. And it seems as if we are not doing our job as Parliament to put pressure in Cabinet. I think DG also mentioned that the Constitutional Court date was June last year. And then you ask yourself, it has been a year after that decision was taken by the CC. And it seems there's no agency on our side as Parliament to address what was decided by the Constitutional Court. So therefore, Chair, I'm very happy that I have to learn here in this committee through this bill, because there's that gap that needs to be fixed between Parliament and the executive. Because each time when we are sitting on the programming committee, the Bills Office always says that this act is in front of the committee. And, you know, when we are sitting in the programming committee, sometimes it's very difficult because we must also avoid to be seen as a person who always opposes everything. But I know for a fact we don't have this act, this bill in front of our committee. But when they update during the programming committee, they always say that this act, or the amendment rather, is in front of the committee. We don't know this bill is still in the executive. Maybe the deputy minister must also come clean with us to share with the community how far at the cabinet level, how far they have gone in order to address this, in order for these processes to come back to the committee. And therefore that where the DG is going to say that, okay, because there is a program about the bill in the committee, so it means we are not going to meet the deadline that was mentioned by the Constitutional Court. Otherwise, we are going to come here and blame each other. And we understand very well that it is an emotional issue, especially on the comrade Typosh on this issue. And I think the comrade saw it at some point, because they understand, as member is putting it, those two comrades or those two members are the one who understand very clear on what needs to happen in terms of this act to be addressed. But Chair, also, if we are saying that all those issues that member Typosh is mentioning is not going to be addressed by the bill, I don't know because last week we were also dealing with Initiation Act, and it was the same or similar situation whereby the leaders through the deputy minister saying that this act does not address the issue that needs to be addressed. So as member Typosh is saying that it's going to be a very worrying situation when we are going to tick the box in terms of making the laws to address the issue. Because if there's a problem in the country or in society, we need to introduce the law to address those problems. But if the law comes back as well as a law that does not address issues, I don't know which other ways that we must apply in order to address those issues of society. I agree with the member who said there might be a problem of resources. That was also the argument that was raised during the Initiation Act. The issue of the resources while there is Act in place. I suspect as well this is an issue with this act as well, because when the Constitutional Court says that no, this is not adequate, this is unconstitutional, I think the cry or the outcry there outside Parliament was that there was not enough consultation. People were not consulted legally. They didn't satisfy themselves. So those are the things that we need to address as a committee in order for us not to tick the box in all other acts that is in front of the committee. Thank you very much, Chair.
Thank you, Honorable Mkalipi. Honorable Sompa and then Honorable Nkosi Buthelezi will come after that. Thank you, Honorable Sompa.
Thanks, Chair. Greetings to all the members of the committee and the delegation from the traditional house and the legal team. I'm not going to repeat what Honorable Kalipi have said. He took some words from me. I'm not going to repeat them. And then my concern that I want to pose to the legal team and the team that is busy with this amendment bill is that, do we have time for consultation? Do we have time? So that we must not repeat the mistake that was done before. Second is that, do we have enough resources to make those consultations? Because it's very much important that everybody must be satisfied in terms of when the bill is passed in Parliament, that everybody, like Honorable Kalipi have said, that it's worrisome if we say we are not going to satisfy all the needs. Yes, it's true, but the most important, the key issues that the communities or those who are affected must be covered by the bill. The issue of the Khoisans, I just want to ask, how can I put it? Is there a researcher that is on place that is doing all the research so that each and every, they must not leave any stone unturned, so that we must be able to know everything about the Khoisan and who are the people who are supposed to be on there? Because if you can listen to Honorable Taibos, he's saying that Khoisans are not recognized in terms of the house traditions, they are not there, and many issues. So we need it. Is there a researcher that is doing all those things so that we must not be found favored the other team or others were not covered in terms of knowing who are the real people who are supposed to be part? Because the issues of the traditional, it's very complex because they are also having its own political, like Comrade Damas have said, Honorable Damas have said, because of there are a lot of politics there in those positions of the traditional leaders. Now, I don't want us to be seen as this seventh administration making mistakes of doing rush things at the end of the day. Tomorrow we'll find another outcome from the Constitutional Court to say the other people from the Khoisan also came to say they were not covered. Now I want everybody must be on the table, everybody who supposeful and rightful so supposed to be recognized, they must be recognized. And I agree with other speakers, the latter speakers, to say Honorable Sol and Honorable Taibos, they are also relevant to assist with those researchers to say this is where to look, this is what we have, because I think also they have their own documents and the background to say this is where we come from and this is where we are now. Thank you very much.
Thank you very much, Honorable Sompa. So your comments are also going to be helpful. When we come back, I think we need to try and focus on what are the issues that are going to be necessary to clear as we move forward. So you highlighted most of those. We'll come back to that just now. Shenge, may we invite you to make your comments?
Thank you very much, Honorable Chair Kabazela. I greet the Deputy Minister, the DG, the team that is there, and of course, I greet my esteemed colleagues in the committee. I've really been mainly taking care of what I wanted to say, especially my biggest concern rather, from what was the comment from Honorable Mkalipi, because my biggest concern is this seemingly gaping gap between Parliament and the executive. And I think that until and unless this is really addressed and is resolved, it's going to be a question of putting Band-Aid on a very deep wound. And I think that we cannot, Honorable Chair, afford to have a hangover from the sixth administration. And I think also as the respective committees, we must be aware that at the end of the day, it's not a silo. We might be different committees looking after different aspects in trying to help the citizens of this country. But at the end of the day, there's a lot to learn from across the board in terms of committees, because if this I know for sure is not isolated to this situation or to this bill rather, especially because I think, if I'm not mistaken, it was the DG who said that the amendments at the executive level were not dealt with due to the pressure of time. And I think these were substantive amendments. And I think then if then a situation like that arises where due to the period of time, not because issues have been resolved, I think it's very concerning, because that's a tail wagging the dog, if I may put it that way. So I think, Honorable Chairman, my concern is that one, that also the finger pointing is not going to help us here. The most important thing is what are we learning from this situation? And also, of course, there are concerns which we need to look at as the committee in terms of cost. If the costs are running away with us and they were throwing good money at the bed, so it really is concerning for me. And I think that maybe emerging, Honorable Chair, out of all this we have covered now in terms of this bill, I think that what would be most important, I mean, from where I sit, I like to suspect from also where most committee members are sitting, my colleagues, is that maybe we need then, probably not to say now, at the end of this session, to have a clear, because there have been very many moving parts now, I mean, as there should be in terms of addressing this matter. If there could be very clear milestones of going forward in terms of where does this take us, and I mean, by how much are we going to overshoot the time frame? Because there is absolutely no doubt now that we are going to overshoot it, and with all sorts of other implications. But I think really that my main concern was that one, that if this is not addressed, again, I just want to sign off with that, Honorable Chair, to say that this gap is concerning because it is at the core, I mean, in terms of the executive and Parliament. And let's just say now, what are the lessons learned in terms of saying the ball was dropped, Parliament was found wanting, one member pointed that out, to say now, what do we resolve? But most critically, I think if we can just round off here with very clear milestones of now, where to from here, because there's a lot that has taken place. At this point in time, I would like to thank you, Chair Nyatoza Kabazela.
So, Alice, thank you very much. Honorable Daibosh, Honorable Direko, I didn't hear your voice. I'm gonna ask you to come out from the woods. I want to hear your voice. But also, Honorable Daibosh, I'm back to you. I said I'll give you some time for follow-up. And I want us to come back then and focus on what we have. After your comments, I'd like us to try and pull the issues together to say these are really the issues and this is how we think we should try and tackle this matter. Honorable Daibosh and Kosub Telezi, please lower your hand so we can recognize if you want to come back. Thank you very much. Yes, Honorable Direko.
Okay, thank you, Chair. I think listening to the questions that have been asked by my fellow colleagues, it also takes us back to what we've been experiencing in terms of the bills and the law that we pass in Parliament, of which in most cases, when people are not happy with the content of the law, they will look for some technicalities in that particular process so that the law could be taken back. So in this regard, we had this law whereby public participation is a challenge, and is not the first law that has been taken to court and we lost as Parliament. So I want to check with our parliament advisors as to, is there any mechanism in place to ensure that in future we don't find ourselves in this particular situation whereby we pass the law and then at a later stage, then the law had to be taken back to parliament due to technicalities. We know that in terms of the parliament budget, we don't have enough funds to cover for public participation. Because I remember at some stage when we were doing public participation regarding some other bills, we'll just go to 2 places in one province. And in that particular areas that we'll go to will not even cover half of the population of the province. And at some point, we then get this situation whereby people say that the consultation was not enough. We only physically went to these 2 particular provinces, or our media campaign was also not enough in terms of the extent of our population. So can the parliament also assist us on that one? And secondly, I know that we are not yet discussing the merits of the bill, but for the people to take this bill to court, it means there are some contents that they are not happy with. Is it possible that when we bring back this bill, that parliament also assists us, check on the legality of this process and also the legality of the bill that we are also going to adopt as parliament? The reason why I'm saying that is because we also have a history whereby we're dealing with a law that we've just passed a year ago, where we're dealing with the political delimitation of the municipal workers. And as a result of that, some of the workers union then was willing to take parliament to court because they were saying we don't have a right to limit the political right of the employees based on the assumption that it causes challenges in their working environment. So we also need that legal opinion that will also give us a stand as parliament to stand on when we pass bill, because we don't want a situation where we pass a law that will also contradict the constitution. Thank you, Chair.
Thank you very much, Honorable Direko. Honorable Typewatch, I'm back to you. If you don't wish to comment again, it's fine. We'll proceed. I just wanted to give you, because I did say I'll come back to you.
Thank you, Honorable Chair. I appreciate it. You know, maybe I need to apologize to members that I become emotional when I talk about being oppressed, being marginalized for the last 400 years, you know. So if I offended you in any way, Honorable Sompa, because I'm getting emotional, I apologize to you, Honorable Sompa, but this is an emotional matter. Unfortunately, you know, if I look at my people and if I know what I know, then I'm suffering and I'm saying, why is it that this one minority group has been left behind for so long? And then they try to fix it, but it's a quick fix, just so that they can be quiet. I mean, if I look at it, I mean, the people that were on this committee that was doing this bill, when we question them, they say, no, let's just get a foot in the door. And once we're inside, you know, we can try and fix things. No, what kind of a bill would that be? This is the NKC, which COCTA consults with on all Khoisan matters. These are our own people that supposedly represented us, but haven't been chosen by us. All right, they work with COCTA and they say to us, let's just get our foot in the door. Just keep quiet for now. Let the bill get passed. If we go back into this bill, Honorable Chair, and we go to constitutional muster, you know, where the bill should pass before it gets enacted, let's have a look, and the records are there. I was told there are 95 red flags raised in constitutional muster. So how does a bill get passed that's got 95 red flags? Just to give you the background of this bill. Chair, this bill does not address the Khoi and the San people as an equal nation or an equal to traditional leaders. Our traditional leaders also don't want this bill. There's some traditional leaders that are heavy against this bill. That's why this Wachiko came in, because they don't agree with everything in there. It's important that we look at the amendments to this bill, Chair, because like I said, I don't know who is more qualified and who can say that, sorry, the Khoisan didn't have kings. Sorry, the Khoisan, there's history. There's archives. It's all there. Why don't we go and you know, unfortunately, the COCTA team was led by a Dr. Bester. All right. Dr. Bester, I met him. Unfortunately, I think he's a racist. And people have reasons why they want to oppress the Khoi and the San, Honorable Chair. We have no doubt that the Khoi and the San are the owners of the land in this country. And there's reasons why the Khoi and the San is being oppressed. So there is a lot of things behind this act, Chair, that, you know, we may not be able to fix it. And I know you're saying, okay, let's not go that far, let's not go that far. Whilst I respect everything you're saying, and I respect you as a chairperson, unfortunately, this thing it goes a lot deeper, Chair, than what you and me can discuss here and what you and me can agree on. So, you know, if I upset somebody's feelings or anybody's feelings, yes, we were the first indigenous nation, not here. We are the first indigenous nation worldwide. Our DNA is the oldest in the whole world. There is no DNA older than my DNA. So, you know, that makes me emotional because why are we are the lowest of the low when it comes to people in South Africa. There's no lower than the so-called colored or Khoisan people. Yet we are the owners of the land and we've been misplaced, we've been pushed from here to there. Here is an opportunity that we can fix things. I'm not saying, you know, we must get everything on a platter, but let's fix it. Let our people be able to live, you know, a normal life instead of an impoverished one without anything, no land. This bill doesn't address the land. This bill doesn't address anything. We've been misplaced. So it is an emotional matter, Honorable Sompa. I cannot deal with it any otherwise because my ancestors, my forefathers, the great Kora, all right, died for this land. While fighting for this land, he died. So you know, I cannot apologize for that, but it makes me sad that today the Khoi and the San people are the lowest of the low. You don't get lower than that. Yet they are the owners of this land. Minerals has been taken out from underneath them. They don't have no land to talk of. Nobody. They don't even have recognition. They don't even have a language. We have languages, yes, but they don't even have an official language. So those are the things that the bill does not address. Thank you, Mr. Chair.
Thank you, Honorable Taibosh. So I think just to deal with your issues, we have the opportunity to bring in amendments to the bill. And when I said we want to address everything, I'm not saying you shouldn't table them, but I'm saying that some of the issues may not fall within the ambit of what this committee would have to do. That should not stop you from tabling the issues of concern that you think need to be part of the bill. I'm just indicating because of the nature of how we've divided the different responsibilities. So that shouldn't be the issue that me and you must argue about. We'll, you know, table the issues and then we will go by the saying that the taste of the pudding will be in the eating. What fits we'll take, what doesn't fit, we need to see how to channel it somewhere else. So I think for a start, the issue shouldn't be whether you should raise the issues or not. That's not the issue. You should raise the issues as much as you think you need to. We will not necessarily be able to cover all of them within this, but they will need to be referred to other aspects. That's all I'm saying. So let's deal with that as the first understanding. In this case, you don't need to apologize. We have issues here. The colleagues were talking about the procedure of dealing with the meeting, which I think we respect, but there's nothing that stops you from raising issues which we feel very strongly about and emotional about. So I don't want you to sit here and feel that you have to restrain your expressions simply because the members are not comfortable. Members are basically saying, let's follow the process of a meeting so that we all have the opportunity. So we're back then to the issues. Now, colleagues, we have all raised our concerns here. And I hope that our team that's recording will record these issues properly. Now, the starting point, which I want us to look at, insofar as this, that we need this bill to be tabled as soon as possible. Now, the question that the members are raising is who is being held responsible for the bill coming back from the court on the basis of technical processing that were inadequate, as well as the cost associated with it. So I think we need to just record that as a matter of the concern of the committee. 4 or 5 members have referred to this particular issue. And Honorable Typos, you will not come in for now. Let me finish what I'm going to say. So I note that you have your hand up again, but we will not give you the space just now. So let's start with that aspect. Now, as I'm recording that the issue of taking responsibility and holding accountable, I just need the members to be aware that the process of public consultations, once it is started and it is in the hands of the committee, then that committee and Parliament itself has to take responsibility for it. Even though we might be looking at who did the program and all of that, but at the end, it's a committee process. And so I'd like us to keep that in mind, because if in this process we're taking now, anything that goes wrong with it, we as a committee have to take responsibility for it. Now, if we're not happy with someone who did something wrong, then obviously we should have acted as a committee to discipline that individual, or as Parliament. I'm not sure how far we'll be able to go with this question, but nevertheless, I think let's follow it up. We can take the matter up with the Speaker's office, as it were, as to who needs to be held responsible. But my understanding is that since the committee was the one that was driving the process, all the functionaries that made errors and so on did that on behalf of the committee. So let's just keep that in mind. And you might want to come back on that if you wish, but I'm saying we'll note it. We might want to raise the issue with the Speaker. So that's the first aspect. The second aspect of it, Honorable Buthelezi, and I think a few other members have raised this issue. We need some form of milestones to look at, a roadmap. From here, what are the milestones of what we're going to be about to do now? Somebody needs to say to us, these are the steps that we need to follow. So between the Secretary and the Parliamentary Legal Services, we need that kind of roadmap. We need this step taken by such a time, this step taken by such a time, and so on. But linked to that should be the costing of what this is going to mean. Just to be able to give us a guide, because from where I sit and listening to what we're dealing with now, I have no doubt that there's no way we're going to finish that within the next 5 months. I'm quite clear that it's going to be longer. If it was just a bill that had no amendments whatsoever and all that needed to be fixed was public consultative processes, then we would probably manage within that time frame. But being a bill that has got envisaged amendments that might come out of the process, both what the department was considering and what Honorable Taibosh and other members might be considering, then certainly this process is going to be longer. Then it brings back the question of who then takes this matter up for requesting the extension by the court. And looking at the judgment, the onus of correction of what was left or of the defects of the process falls onto the speaker and the legislatures, and less on the executive, both the minister and the president. So I think we must be aware as well that this process needs a very strong backing from the parliamentary, from the parliamentary process, because of the weight of the judgment having been over those particular institutions. So that, for me, is something that we need to note as we move on, because that is ultimately where the responsibility will have to fall for the extension, which in my mind, and I'm not saying that this necessarily will be the case, but in my mind, it's inevitable that this is going to be where this thing is going. Where we need to put criticism to the executive is the fact that the judgment was in June and the bill is not back to Parliament by September, which is more than a year after that. I don't know what would have stopped this bill from getting back to Parliament by 2023, because there was no amendment foreseen or processed. And so where was the delay? Was it the department that was changing the dates for 12 months before the matter went to cabinet? Was it the pipeline of cabinet backlogs of matters that they had to deal with, and so on? But if we need to raise that, then let's raise it in the context that June was the judgment and September we still don't have the bill. Yes, there were elections in between, but if the members want to raise that as a point, I think let's note that. So I put that issue aside, therefore. Now, we need to have a way of estimating the cost of this. What will be the cost? Because the members, from the first member who spoke, Van Zyl, to several other members, they've raised the issue of the cost. Yes, I understand Honorable Ndamasa says democracy is expensive. We want to know how expensive will this process be? Then how do we balance the thoroughness of our processes with the cost, so that in the process, we don't end up spending more again, only to find that we get back at the end and be actually penalized for not having adequate consultation. That's on the technical side of this bill. Then we come back to the substantive amendments that are going to be part of this. Somehow, it looks to me like we might need to have several of these matters that are being raised tabled for the committee even before the bill comes. So, for example, what were these amendments that the department was considering? Even before the bill comes to us, let's look at them. Then it prepares us for the processes we're about to go into. Secondly, what are these issues that Honorable Taibosh believes should have been part of the bill? Then by the time we go all out to public engagement, we already have been pre-warned of these issues, because if we do, we will be in a better position to guide the discussions at the public consultations and the results of the consultations, because we already understood what the nature of the issues were. And I'm saying this because some of the issues that would be tabled, it is better if we knew that these issues are already envisaged for amendment, so that we can flag them as people are making comments at the different hearings. That allows us a space to be able to say, okay, these issues are fairly strong, therefore, they're in line with some of the amendments. Maybe the amendment that was proposed is not adequately addressing the issues, or is not focused on what the issues that they are. Just for our own background understanding before we can go and engage. But to go into the public hearings without knowing what is it that the members were considered is another issue. Now, Honorable Mkhalipi is saying it has been said that the General Amendment Bill has been with the committee, and of course the committee has not received this amendment. But if you listen to the DG says no, the amendment bill will be was prepared, but it has not been sent through because it was felt that amending the bill was going to cause a lot more delay. So there's something we need to understand on where we are with that process because of what Honorable Mkhalipi is saying. So we mustn't be accused of holding or knowing about the bill when we don't have it. But my point is we need the content of that bill to be known to us so that we don't fly into this thing blind. We need to be able to determine whether there's adequate time to be able to amend those, to effect those amendments. The reason why I'm saying that is because certainly the processes of going back to getting the amendments effected might have another impact on the consultative process themselves. So we need to keep that in mind. So having said all of that, then I want to come back to the issues that are raised by Honorable Taiposh. Honorable Taiposh is saying that there are many issues that have been raised. There's the issue of the language, there's the issue of the amendment to the Constitution, there's the issue of the mineral rights, there's the issue of the land use rights, and the general status of the Khoisan people, the marginalization, and so on. So we do need to be able to say, of those issues, which ones fit onto this bill and which ones do not fit into the bill. That does not mean that they are not legitimate issues. It does not mean that issues will not be attended to, but it means we need to be able to say, where should they be referred to? Then we can then assist the process that way. With that, then, it seems then to me that there's a bit of additional preparatory work that needs to be done as we await the tabling of this bill. Now, Honorable Taiposh talks about 95 red flags. Maybe we need to see those red flags before we even deal with the bill. So that for me would be important. Then Honorable Sompa is also raising a very valid point. We cannot go into this process without our own research as a committee. The research will help us to say which are the group of the Khoisan community that have to be consulted, because it again doesn't help if we leave out a large number of communities because we didn't target them properly. And also on the one side, you can actually consult people who are in the same kind of category, and many of them in the whole country, and yet leave out others who are in a slightly different category. And therefore, our experience as a committee gets skewed because of the fact that we didn't deal with the various communities in their length and breadth. So we need to have a better guidance at that level. And on that basis, I did ask Honorable Taiposh to give us some of the research or researchers that they've been working with on this matter. Let's just try and bring everything together so that this committee does not get into this matter blind. It's a very noisy process. There are all sorts of tensions and conflicts that will be found, but we should expect that these communities will always have differences of opinions. That should not really discourage us. So with all of this, I'm saying that we need to do a little bit of preparatory work ahead of this. It's not as simple as saying that all we are correcting is public participation as a technical process. I think we need to try and understand the issue much more deeper because of the gaps that I think all of us are identifying. But the members are saying they are very keen to have a better guidance in the processes of consultation to be able to see the timelines that are involved, to look at the implications of the delay, to look at the cost implications, to look at the issues of consequence management. All of those issues will need to take into account. So with that, honorable members, I'm hoping we can have a much more much better preparation for the submission of this bill. The bill mustn't just find us cold. It must find us already warmed up by the background information that we would have received, so that we understand the issue better, and that will enable us to handle the matter better than what would have been if it just found us cold. But having said that, I still think that we have got a huge risk of overshooting the timelines that were set by the court. And so all the preparatory work needs to be dealt with. That's how far I would think we should take this matter. Any other issue that colleagues feel that we might have left out? Round-up comments? Honorable Taiposh, you had your hand up again. There's a new issue there. And
Thank you, Chair.
Yes.
Just in terms of the researcher, I did pass on the information of a researcher that's based at the University of KwaZulu-Natal that I use. I did pass that information on to the portfolio committee researcher, the contact details, all right? And then, Chair, thanks. He hasn't heard from anybody yet, so I just checked with him while we were talking. And then, Chair, to come back to the timelines, if I look at this, the provincial, the timelines that this act is suspended until, well, May 2025, the process involved to recognize a Khoisan leader, all right, could take about 2 years according to the commission that was appointed by COCTA. Now, I'm just looking at from 2025 or 2026 for that matter, another 2 years. So it could be only in 2028 when we have our first recognized Khoisan, whatever it is, a headman or a chief or whatever it is, besides even just the bill, So I just wanted to say the timing issue here is really a problem in terms of the Khoisan descent. We are in 2024. It looks like it'll be another 4 years of suffering for my people before anybody will be acknowledged. My problem is, where is the equality? There were traditional leaders recognized without this process. Why can't the Khoisan descent be awarded a process as well that doesn't need this process to be recognized and also enjoy the benefits of their country? Thank you.
Okay, thank you. Let's deal with that issue as we move along.
Okay.
Effectively, there are two things that are involved here. One is a framework bill that will allow us to say, in terms of our approach, everyone is the same. And that's what point that I think this bill is about. Then the question of who and which house, that might take a little bit of time. We've had that Nhlapo Commission in the same way, so that will be an ongoing process. So I don't think we should feel that dealing with the act on its own is not helpful, but I think we should separate the fact that the determination of the rightful houses and levels, as well as individuals to ascend to the position, is something that might take a while, even though the institution is already recognized. But we'll get through to that. Your point is noted. Then, Honorable Koike.
Thank you, Chair. I'm just wondering, my question to Mr. Prince, is it going to be answered?
Okay, just remind me what your question is again. Let me just check.
My question was that they made a request on progress on the 10th of September. The presentation does not express whether there was a reply. If there was a reply, what was that formal reply in terms of the progress?
Okay, Honorable Prince will deal with that question. Then Honorable Ndamase.
Thank you very much, Chair. At the beginning of your summary, Chair, you were trying to respond to the question as to who can be held accountable. And in that summary, you also included the committee. I would like to suggest otherwise, because we are at a lower rank as a committee. And I'm not surprised that the Constitutional Court is directing the Speaker in the form of Speaker as well as the Chairperson of the National Council of Provinces, because that's the executive authority of our National Assembly. And therefore, we may not take any decision, for instance, if Parliament says it's because they don't have enough money to allow for public involvement. And we can sit here as a committee and we cannot be able to do any other thing, because we are not empowered to do anything in terms of how to approach the matter. For us, it would be to plead and plead and plead. I would therefore say it might be dangerous for us to assume that the committee can be held responsible for the work that has not happened because of whatever has been observed or has been decided at the level of the executive authority. Thank you very much, Chair.
Okay. All right. Let's note your point. I don't want to us to get into that debate. Let's note your point. We'll have to follow the matter up. Honorable Deputy Minister, colleagues, by the way, we asked for the public participation team to come in, and we'll give them another 15 minutes to take us through their presentation, but I wanted us to deal with this one whilst it was still hot. Honorable Koike, please pull down your hands. Honorable Deputy Minister, you're on the floor.
No, thanks very much, Honorable Chair and Honorable members. Let me also, Honorable Chair, indicate that we also have Deputy Minister Masomula as part of the delegation of COCTA ministry. Is part of the meeting. I think, Chair, we have had the guidance from the committee. We will convene once again, taking into account all the points that have been raised, and make sure that from the point of view of the executive, these matters are attended to in a manner that will ensure compliance with the Constitution, but also being sensitive to the truncated nature of the time that has been set down by the Constitutional Court, in ways that will also enable Parliament to follow its thoroughgoing processes that equally must ensure compliance with specific sections of the Constitution that relate to public participation, 59, 72, 118. So we want to commit that we will always be ready for any time that Parliament would so require us to come and update. I think that is the commitment I wanted to make, Chair, on behalf of our team. Thanks very much.
Thank you very much, Honorable Deputy Minister Masomula. We do acknowledge your presence, and if you want to make any comment before we move on to the next aspect, which is public participation, let's welcome you if you wish to make any comment. Honorable Deputy Minister Masomula.
A very good morning, Honorable Chairperson and my colleague, Deputy Minister Chawe, and honorable members of the committee. Well, the Deputy Minister has summarized the discussion on our side. The Honorable Chair is just to indicate that we remain committed to working together in finding solutions to these matters that are before us as the committee and, of course, as the department. I was just saying good morning to members of the committee. We are led by Deputy Minister Ngamase in this meeting, and he has correctly represented us in that regard. Honorable Chair, thank you so much.
Thank you very much. Look, Honorable Deputy Ministers and DG, you, of course, recognize the fact that the committee will be very keen to still understand the basis of the more than 1 year's delay. We do understand the fact that there were 2 months when we had to halt a lot of things because of the elections, but it's a bit difficult for us to understand the almost 14 months delay from the time the Constitutional Court made the ruling. So we will still need to reflect on that and get back to the committee. This is important because sitting here, somehow the committee has a feeling of helplessness if we're supposed to be held responsible by the court on behalf of Parliament, but at the same time, the process for 14 months was outside Parliament to get us to respond to the court requirements, when in fact there was no new substantive amendment expected of the bill. And so that remains an issue that we really have to put on the table to say, we do need a response to that. And I think on behalf of the members, let's recognize that as an issue and recognize the fact that we still don't have the bill, and therefore we wouldn't be sure at which point are we able to start counting. We asked the DG, and the DG says he cannot be sure as to when we might actually start our count as the committee, on a countdown towards the May 2025. And so that for us is the biggest area of concern, that we're not in control of the process until the bill is with us. Even though when it is with us, there are many issues, but nevertheless, what can we do to make sure that this bill doesn't only land us with the committee in November, December, when we're kind of closing down and won't be able to act on it until the opening of the year in 2025, and then we've got even fewer months before the deadline is hit, and yet we have to go out and make an application for extension with the court. So I think that point needs to be tabled and be recognized by the minister and the department, that it's a serious disadvantage for the committee, as it were. Having said all that, we have highlighted areas that are going to be important for us to do the roadmap with timelines, and also the costing associated, and the questions of who is responsible for what, and then look at that. And the second group of issues is recognition of doing research to have a background understanding of the communities that need to be included in the consultation, as well as research to look at issues that need to be tabled for our consideration ahead of the amendment, so that we know how to handle them as we move forward. So there, with that, colleagues, let me say we'll hold this discussion at that. Let's now deal with the next presentation.
Honorable Dr. Mkhize.
Oh, sorry. Let me just ask Honorable Ashley Sauls has raised an issue. Can Mr. Prince respond to that issue? Sorry, I forgot to get your response. Mr. Prince, do you want to respond to the issue?
Yes, Chair. Chair, I was just informed that the department, in fact, have replied to our letter. The department has indicated, like the DJ has mentioned in his presentation, that the matter has been sent to Cabinet, and it's hopefully will be serving before the Cabinet meeting of the 18th of September, which is tomorrow, for the approval to table the bill in Parliament. And then the correspondence go on to say that it is envisaged that the bill will be introduced in Parliament by 31 October 2024. That's the only additional information that we've received so far, Chair. Thank you.
Honorable Koika, are we covered?
Yes, Chairperson, is it possible for that correspondence to be shared with the committee?
Okay. That correspondence shall be shared with the secretary of the committee, and that secretary will share it with the members. And yeah, honorable members, let's take the next point. The secretary is going to help us to pull together the issues that I've raised, so that we, together with the both the department and the legal team, were able to look at the roadmap on this matter going forward, and all the other implications that are associated with that. So thank you very much. We close that issue. Let's deal with the issue of public participation. Let's have the team. I don't know if I've got the names of the team on the public participation here, but may we invite that team to give us the presentation. Please introduce the team as well. Honorable Deputy Minister, please lower your hand. Hi. Oh,
Morning.
yes, Honorable Beck.
Good morning, Chairperson, Honourable Deputy Ministers and members, as well as colleagues on the platform. My name is Rashida Beg. I'm the Division Manager for Core Business Support. We are largely responsible for committee support to all the portfolio and select committees, as well as public participation. And then we also have the office supporting the leader of government business. I've invited on the platform Mr. Brent Simons. He's the Acting Section Manager for Public Participation. And with your permission, Chairperson, he's going to take the committee through a presentation around how we're going to do public participation differently, to make sure that we're able to assist this committees as well as other committees, particularly with the lawmaking process. Thank you, Chairperson. Through you, I'm handing over to Mr. Simons.
Please proceed.
Thank you, Chairperson. Honourable members, I just want to clarify with the Secretary if I share the screen or if it's done from her side.
Good day, Mr. Simons. You can share the screen. The platform is open for you to share. Thank you.
Okay, can colleagues, honourable members, can you see the presentation?
Yes, proceed.
Okay, so yeah.
Am I the one who doesn't hear you,
I'm
or are you the one who's not being heard?
I'm just struggling to see it from my side quickly. I'm just doing something to the okay. As the legal representative of Parliament took the committee through it, we're not going to focus on the court judgment itself, but just to indicate to committee members that obviously the court ruled that Parliament needs to provide citizens with a meaningful opportunity to participate in the legislative process, so that they can at least be given that opportunity to strengthen and influence the final product. The court has also set a standard for public participation, facilitated by Parliament, and in that process it clearly outlined that Parliament actually has a framework in place, and all Parliament needs to do is to actually ensure the implementation of that framework. Now, factors impacting reasonable public participation. I think our legal rep also took the committee members through that. But just to remind that obviously what impacts the importance, I would say, of the legislation itself would be the nature and the importance of the legislation, the impact that the legislation would have on the public, whether that is nationally or whether it's only an impact on particular provinces, etc. Those are things that the committee and parliament actually can determine for itself. Then also the court recognized that there would be time constraints and also resource and budgetary constraints, but that in itself should not be used to justify inadequate opportunities for public involvement. So the court recognizes that you might have certain problems, as honorable members have identified and alluded to, but the reality is that we still need to develop mechanisms and ways to ensure that we consult and involve the citizens. So Parliament has also then adopted the new rules, joint rules of Parliament, and in that joint rule 12, it actually clearly outlines there that the public participation in terms of sub-rule 1 is subject to and must be exercised in accordance with the applicable provisions of the Constitution. These joint rules, as well as the public participation model. And this is something of a new approach from a parliamentary perspective, because now you have the public participation process outlined in the public participation model, outlined and adopted in the rules, joint rules of Parliament. So we're going to touch on what that means for the committee as well. So colleagues, in terms of the Constitutional Court judgment, it identified this particular piece of legislation that the committee is dealing with as of immense significance, impacting millions of South Africans, and therefore it requires that Parliament actually follows proper, meaningful public hearings in all provinces, according to the court itself. So the court then also said, look, what would be the features of reasonable public participation? And it says there pre-hearing educational workshops, effective communication and awareness programs. Obviously, any material that you produce must be produced in the local languages. And the court also specified that at least in 3 of the local languages you have to produce the content. So we have community mobilization and attendance and at public hearings and consultations. So the court says that it is the responsibility of Parliament and obviously its relevant partners and stakeholders, but the emphasis on Parliament to ensure that we mobilize communities. So we have actually combined communication workshops, awareness workshops, educational workshops as part of the process of community mobilization. So what we're telling the committee is that as we are beginning to embark on these educational programs, on these awareness campaigns, on information sharing campaigns, we also use that as a mobilization mechanisms to ensure that citizens actually participate when it comes to the actual public hearings. So courts also then, the various courts, but the Constitutional Court also placed the emphasis on this. The provision of transport to and from venues remains a responsibility for the institution itself. So obviously that would also impact, as honourable members have highlighted, impact the budgetary implications of having public hearings as well. Because if you're going to transport people to a venue, you pick them up in the morning, you also, at least to some extent, have to provide them with something light to eat for lunch. Then the invitations to be sent out 5 weeks prior to the public hearings. So the court is saying that you need to at least give all your stakeholders, including your citizens, that you are inviting to come and make presentations, at least 5 weeks notification in terms of ensuring that they are then able to familiarize themselves with the content, and then also to take to actively participate in the discussions when it eventually happens. So from a provincial legislature perspective, we also need to ensure that we at least give them and they give their relevant citizen stakeholders 7 days notice of a public hearing. And then where the NCOP has delegated a provincial legislature to hold and stage public hearings on their behalf, the court said permanent NCOP delegates must attend those provincial legislative organized public hearings. So NCOP delegates are therefore required to attend that particular hearing. Then, in terms of the joint rules, time limits to process the bill, as you've heard now, Honourable Chairperson, it is something that the committee has and Parliament has control over. So for example, if you are saying now that there needs to be an approach to the court for an extension so that Parliament can properly consult, that obviously to some extent would also influence the proposal that we are making in terms of embarking on an education campaign. So we're saying there that adherence to time limits, a time limit set for the completion of any step in the legislative process is compulsory and must be complied with by the person, the structure, and important there, colleagues, the committee. So I think it is important for the committee then, from your discussions this morning, to determine what it is that you want to do, and if you're going to ask Parliament to approach the court, then we do that, and obviously the institution and the committee then determines once that extension is granted. You then determine when you are going to go on your public hearings, and then we will accordingly amend our dates for any proposed program. So the public participation model that we have adopted is in front of you now, colleagues. The emphasis there is on informing citizens, and that is providing them with an opportunity to attend workshops. It is informing them through information leaflets. It is informing them through community media engagements. It is just the broad process of ensuring that we start this process, and we will obviously propose to the committee that once you have now agreed that you are going on to a public participation and a public hearing process, that we start off with at least a media briefing hosted by the committee and led by the committee chairperson at the parliamentary precinct itself. So that then takes us to the next phase, which means that we then embark on extensive educational workshops, which we refer to there as our pre-hearings, and that itself, honourable members, we will train and capacitate all the officials who will be going out for these workshops in partnership with your content advisor as well as your researcher, and even if it means that we need to get someone from the relevant department in terms of traditional leadership to also take us through the content, then we will arrange that, and we will make sure that we properly capacitate officials so that they are at least able to also answer questions if those questions are raised by citizens. So from the consultation, we move to involvement. And remember, honourable members, I said we will inform, we will educate, we consult, and throughout the process, we ensure that at least the people we capacitate in terms of educating them about the content of this bill will be able to effectively and meaningfully participate at the public hearings. Through the consult, the education, the information sharing processes, we also make it very clear to citizens that when the committee arrives, you are not going to deal with the issue of crime, for example. You might not be dealing with the issue of health. You will be focusing on the law that you're trying to efficiently and effectively pass through the parliamentary system so that it becomes law in South Africa. So then a process that we have also neglected, which the court has highlighted, was that once the committee pulls out and you embark on your consultation, once you return to the precinct, what happens? You don't inform citizens about how the information that they have shared and the input that they have shared with committees are filtered into the new legislation. So I think that is important for us. We will also share with the committee a process that we will embark upon in terms of making sure that to a large extent we give feedback to the areas and to the communities which the committee actually went to for public hearings and public consultation. So the emphasis then on informing, consulting, educating, involving citizens, and then providing that relevant feedback in terms of the adopted model for public participation by the institution. So our public participation model provides, and I think the chairperson correctly pointed out that even though officials might be designing the process, I think the ownership of the entire process lies with the committee, rests with the committee, because we will present our plan to the committee, and the committee will then adopt and endorse that. And therefore, you can see in that first column there, in terms of accountabilities and responsibilities, honourable members, the committee chairpersons are held responsible and accountable for ensuring that we do our work as well. We will make sure that we do our work, but we've now worked in a mechanism where we're going to report back to the committee to say, these are the workshops we've held, these are the pre-hearing workshops, we went into these particular areas, this is how many people attended. We will be able to provide evidence of attendance registers, photographs of the workshops itself. If we had an extensive media campaign, we will also be able to tell you that on these radio stations, in these community radio stations, these community newspapers, the particular national and provincial newspapers, we would be able to keep that record for the committee and provide it to you, so that you're also aware that if you do go into an area, we have saturated that area extensively in terms of trying to capacitate citizens. And then just as one honourable member also said, we would not be able to reach all the citizens in this process in a particular area. But our objective is going to be to make sure that at least in that area, people are aware of the committee coming, and this is why the committee will be coming. And then also through our provision of leaflets that would be produced in their own languages. So from this slide, then, colleagues, we go to the process exemplar there. We're just breaking it down here, and we're saying what we will do is provide the committee even before you go on your public hearings with a high-level, detailed program, which will include a stakeholder engagement strategy. And I think it's important for honourable members to recognize that perhaps some of the key stakeholders we should be targeting at the initial phase would also be the ones who approach the court in the first place, in terms of ensuring that they challenge what Parliament has done. So that would obviously be key stakeholders that we need to educate, not educate, but consult, so that we can identify also what it is that technically we can improve on and do better. So the stakeholder strategy will not only be a national one, it will also be a local one, as well as a provincial and a district one. So we have identified key partners in terms of the relevant lead government department who will be consulted. And for us to embark on this program, obviously, we have also developed a strategic partnership with GCIS. We have already sent them a very formal email telling them that this bill will be coming and that we will have to embark on a consultative process again and extensive public hearings throughout the country. So we want them to activate their stakeholders as well. So as soon as we get the go-ahead, we will then activate those plans that we have already started working on. So the pre-event public education workshops, the committee will know exactly where we will be going into, and that obviously would be an emphasis on the area immediately around the identified public hearing venue. So we will saturate the wards around there, and we will work up to between 50 to 100 kilometers away from that particular public hearing venue. There will obviously be a media strategy with a specific focus on community media, and this will all be part of the high-level detailed program plan that we will submit to the committee, and then obviously provide feedback to the committee chairperson and the committee on a basis consistently, and also to be influenced and determined by the committee itself. So the establishment of the program in terms of making sure that this is the bill, the content has been produced, the content has been summarized, and the content has been provided to the language and translation services of Parliament, so that we begin to at least, by the time we are ready, we then say to the committee that we have produced the draft bill or the draft content in all the official languages. We are going to print leaflets, and these would be going into particular areas. So members have raised concerns with the procurement of services. That obviously would not solely be the responsibility of the public participation section. There would be other key stakeholders within the institution who would obviously take responsibility for organizing and ensuring that the logistics, once it has agreed the venue, that everything around that particular venue is correct. So even when we do the review program and we provide that feedback to both the committee with a specific focus on feedback to citizens, we would basically conclude our report to that extent in terms of making sure that the committee consistently is kept abreast in terms of the development. So colleagues, the public participation process flow would outline there that we need at least 6 weeks, and you can see the input there. And remember, colleagues, this is part of the adopted joint rules of Parliament now, and there is a regulation there that says that at least we need to ensure that we comply with the time frames and the timelines and the deadlines for us. So the need identified, we're saying that we need at least 6 weeks prior to the public hearings to develop our own plan, to ensure that we begin our stakeholder analysis and engagement, which would be part of our environmental scanning report. So honorable members, we are not going to reinvent the wheel here. We will work very closely with the Government Communication and Information System, because they have a ward-based ward information management system they call WIMS, which would incorporate all the data that you have from the HSRC, from the Stats SA, from various institutions that collect statistics on behalf of government. So they would be able to print that and then also say that this is the problems in a particular ward or in a particular community, so that we begin to include that in our environmental scanning and our environmental assessment. That would obviously also include the report of which local-based media would be available in those areas that we can utilize, all the stakeholders that are operative in that particular area. So we then design our pre-education needs implementation plan. So we've now identified where the committee will be holding the public hearings. We are now going to go into those areas 5 weeks before the time to begin to have our pre-hearings. And Chairperson, I remember you were one of the chairpersons who said you cannot ignore ward committees in areas, and that is why we're saying that we would have a ward focus in terms of public participation, in terms of educating public and citizens in particular wards, and that would not take place without the ward committee and being involved, the ward councillor having been informed that we're having these workshops, etc. So the logistics, obviously, I'm not going to focus on those particular issues regarding the logistics, but just to confirm the committee, to appease the committee at least, that there will be a structure that will be established, obviously in partnership and reporting directly to the MANCO of the committee, so that the chairperson and committee members are consistently aware of what is happening in terms of the planning leading up towards the committee itself. From our side as public participation, our emphasis is going to be on ensuring that we have ward-based, community-based educational workshops, which takes us to the next level there, which would be the mechanisms that we are using. And as I indicated, Chairperson, we will use various platforms in terms of community media. We will be distributing leaflets in the relevant languages, so that people at least understand it in their own language and conceptualize it in their own languages, so that they have a clear understanding in terms of what the committee is coming to do, what the bill is seeking to address, and that if they have any questions, they can begin to start asking them in those pre-workshops, of which we will also begin to keep a record, so that when we do give a preparatory briefing to the committee at least 24 hours before you go into your public hearings, that we will say these are the issues that citizens themselves have raised or which stakeholders have raised themselves, so that the committee is aware at least of what to expect when you go into public hearings. And then obviously the output in terms of having those meetings and making sure that as many people as possible attend the public hearings and participate in that. And I think, honourable members, if you've read the Mogale judgment, you would see that the court made it very clear that yes, your traditional leaders are stakeholders, but if you consult, you need to allow as many voices from the ordinary citizens to be able to address you as well. And I think the court gave certain examples as well in terms of where only traditional leaders were allowed to address the committee, and the court said that that was insufficient because immediately you then closed off the gap for not the gap, but the constitutional right of those citizens to then voice their concerns and also be able to participate in the process in front of the committee. So colleagues, we're then saying that the 6-week process to ensure that citizens are informed, educated, consulted and mobilized to participate. So again, the court ruled there that when Parliament enacts legislation, it must take reasonable steps to facilitate public participation. And the module that Parliament adopted is based on international best practice. It is also based on what has been considered appropriate by courts in South Africa. So we're saying that the 6-week period would be utilized to inform citizens, to educate them, to ensure that they at least are provided with the correct information. And yes, one member said that we have not printed and we didn't distribute, and that is what the court found, that so all the issues highlighted by the court will actually be addressed if you adopt the 6-week process for public participation, to go into all these areas, to begin to educate, inform, and ensure that people are capacitated with the correct information so that they can actually attend our pre-hearing workshops, that they at least have some information in front of them from a parliamentary perspective, so that when the committee arrives, I had someone there, Chairperson.
Honorable
Chair?
Khalip.
Yeah,
Honorable
no, I
Khalip.
just want to check, Chair, how long does I have? Because I think we must
Yes,
also give them timelines, right?
I said we'll do 15 minutes. We've gone for almost 25 now.
We are going to conclude
Please round
now,
it out.
Chair.
Round it up, please.
Yes, Chair. So the objective is to involve. So all we're asking the committee, Chairperson, is that give us a 6-week period. The colleagues, I'm sure the secretary has either shared it already or will be sharing, but we give you a breakdown there in terms of what we will be doing in terms of week 6, week 5, week 4, before the committee comes in, 3rd week before the committee comes in. We would then be increasing our information sharing and educational drive with a specific emphasis on, again, capacitating citizens in and around the areas. In weeks 2 and 1, we continue with our pre-hearing ward-based workshops with all our relevant stakeholders, and we will stay in those areas until the day before the committee has the public hearings, chairpersons and committee members. So colleagues have raised the issues around resources. I just want to inform the committee that we only have 8 public education officials known as practitioners who will be going throughout the country before the committee goes into an area. We are trying to obviously use this human resource restriction a bit better, because it is incapacitating us to a large extent. But we said we will also begin to train relevant stakeholders try and ensure that we at least have more feet on the ground. Our parliamentary democracy offices are operational in Limpopo, the Northwest and the Northern Cape. And before you go into those provinces, all our public participation activities will be coordinated through those offices. Chairperson, as I indicated, we will be printing documents in all languages. The potential risk, I think that we've had safety concerns around staff members, the long driving hours to and from the venues. And that, Chairperson, is why we are also going to, in partnership with our stakeholders, also give some proposals to the committee to consider in terms of saying perhaps these venues would be more appropriate instead of taking people out of their townships and the rural areas into CBDs where we utilize metro municipal town halls. We're proposing that we go into those communities. And then because of the tight timelines, Chairperson, we will also obviously say that in some of these public hearing processes, committees have actually split themselves into two groups so that they cover as many community areas as possible. So how will we coordinate the PP program? We've touched on that, Chairperson. This is the stakeholders, and you will see that your work committees is there identified as a key stakeholder. Community radio stations, the school governing bodies and municipalities. So we will not be going into those areas without ensuring that the municipality and the provincial legislature is informed and the local council is also on board. I'm not going to touch on the community radio slide here, but this is just to give you an indication in terms of the extensive feedback process and mechanism that we will be embarking upon. This I think is important for the committee to note. We are about to enter as the institution through the PC on Home Affairs, a consultative public hearing process regarding the marriage bill. So this is what the committee has provisionally adopted. For example, we have the summary of the provisionary bill. We know what it aims to achieve. We have identified the relevant stakeholders. We have also indicated that because it is the marriage bill, and because it deals with customary issues, we are probably going to focus more on rural communities in the provinces all 9 provinces that we are going into. But because it also touches on the issue of Hindu and Muslim marriages in the provinces that we have metros, we have proposed and the committee has accepted that we actually have those workshops in the metropolitan areas as well. So what's important to note there is bullet 4. For example, the committee will be going into KwaZulu-Natal on the 15th to the 16th of November. And as a result, we have been given the responsibility of entering KwaZulu-Natal from the 1st of October to the 7th of November. So we've already met with our GCIS counterparts. We are activating the Provincial Government Communicators Forum. And through the Provincial Government Communicators Forums, we are activating district communicator forums. So we are having that as an extensive outreach. The content workshop is organized for next week, the 25th, where we will also be inviting the GCI's provincial deputy directors, for example, so that they themselves have an understanding of the marriage bill and thereby extend the reach of Parliament. And when they have educational workshops on the marriage bill, they will always have a parliamentary official present.
Chair, this is an abuse now, Chair. This is a really abuse of this person.
It is the
okay.
Chair, my apologies.
Chair,
My
apologies.
apologies.
I agree, Chair. It's a total abuse now. 15 minutes. I don't know what clock and watch they are looking at, but this can't go on like this. It's abuse of the members here in this house.
Let's close. You've got 1 minute to close down.
That's the last slide I was touching on, Chairperson. But as you can see there, this is the plan we presented to a 6-week plan we presented to the PC on Home Affairs regarding the marriage bill, and it was adopted. So all we need to do now is activate it. So my apologies, honourable members. That is what we're putting on the table. So as soon as we get the go-ahead from the committee, we will start activating our plan, and we will also link our plan then to the actual dates that the committee has given us. Thank you, Chairperson.
Thank you very much. Can I just check something? How quickly will it take for you to give us this draft plan for this bill? Now, I know we don't have all the dates, but we're just considering what the court has raised so that we've got the framework of what this will be about. How long will it take for that? We need the roadmap.
Chairperson, I will immediately activate some of our I will activate our responsible officials immediately after this presentation. And if the committee wants us to do a presentation on the actual outline of the plan, we can do that for the committee within the next week or two.
All right, within a week, you will submit that so that you'll discuss it with me and the secretary, so before we can bring it to the committee. So let's do that. We give you about a week to do that, then I'll bring it to the committee thereafter. But thank you very much for this. Honorable members, I think all we needed from this team was just to have an understanding as to how they go about it. There may not be much to discuss other than the fact that we need to start a roadmap for the traditional leadership and Khoisan bill. So that process, we should be able to table back to the committee in about 2 weeks just to get a sense as to what do you think is possible to be done. And we'll then have whatever additional information at that point. Honorable Taiposh has given us the researcher, so we will try and see how much of the information we can get to feed into this process so we can table for the committee process and the way forward. Any other comments, colleagues? I don't believe there's much
Chair?
to discuss on this one. Yeah. Yes, please, Honorable Deputy Minister.
Thanks very much, Honorable Chair. As I was listening to Mr. I think Simons, if I'm correct.
Yes, Simons.
In all the institutions, in all the institutions that he has made mention of, I've not heard him talking about traditional councils. Traditional councils, each and every, most of them have got public servants or civil, the secretary of traditional councils, who are paid government officials, who could be used as a resource in terms of facilitating some of these information sharing sessions, if they can incorporate, because it means most of the communities that would be affected by the functionality of the legislation would have information, would have an opportunity to have that kind of information. So I want to sponsor a view that in their planning, they must also involve traditional councils because they will reach out easily to get to traditional communities. It's a gap which I observe. I thought, Chair, I should say that. Thank you very much.
Thank you very much. Let's note that, and what might be helpful for us is that in the process of communicating, let us see if there's a database of traditional leadership in the country where we can actually feed the entire process as we move along, even if we may not be able to reach there, but when there are invitations, we share them across all traditional leadership so that at least we will say that they were aware of where the hearings would be, and therefore that helps us to be able to say the reach was wider. Honorable Taiposh?
Chair, I don't know if I missed this or not, but there was something that happened in the past. You know, it was public participation for you know, also for the Khoi understand and for traditional leaders. But what happened is the people that scheduled this scheduled it at a venue that we had to take 2 buses or 2 taxis in a wide suburb where there was basically no so-called traditional leaders or Khoisan people living. So I just wanted to check, how do we prevent that from happening?
Okay, note your point. when we bring the framework of the public participation next time, then your focus should be on the venues so that we can address that issue. I think there are two things about it. One, if there is a sense of lack of knowledge as to where the people are that have to be addressed, it's a problem. On the other side, you could be having a problem where the communities are so far apart that the central place where you can get them is a town nearby, then it might be the issue. But let's not deal with it in theoretical terms. Let's deal with it practically when we look at the framework. So at that point, you'll bring back your point.
All right, Chair.
Thank you. Honorable members, any other comments? This one was more information, and I've already issued the guidance as to what we need from this committee. We will have them presenting to the chairperson and secretary of the committee, and then hopefully in 2 weeks' time, we should be able to table a framework of how we're going to go about this in line with your decision that we need a roadmap towards the dealing with the consultative processes here. Honorable Sompa?
Thanks, Chairperson. My request only to the PrEP committee that there must be fairness in the entire process and transparency. That's all we request on behalf of this committee. Thanks.
Fair point. That's a fair point. So when the process comes back, we will obviously look out for those concerns. That's fine. Let's take it from there. The team must just note your concerns on that matter. Okay, thank you very much. Can you take us through the agenda again?
I thought, Chair, my hand was up.
Your hand is not visible. Something in your gadget does not allow us to see your hand. So I give you the opportunity to comment.
Thank you very much, Chair. Just two comments for me. The first one is that it's a serious indictment, Chair, for the Constitutional Court to be telling us about what could be called an ideal public hearing. And that means we have gone wrong as the legislative arm. And we must not forget that the same legislative arm was in front of the Constitutional Court in 2018 on the Lamusa judgment. And it is identical to what was said in 2018 that has just been said in relation to this piece of legislation. And that must never leave our minds, because we will continue doing wrong things, and then we're dragged to court, and then we have to go back and do things once more again for apparent no reason. Then my second point is in relation to the public education process, which I have seen being led by the officials. By public education, and in preparation for the public hearings is led by officials, which sometimes creates a problem. I would therefore recommend that there must be a way of integrating the members of the committee to be able to take a lead in the public education process. Thank you very much, Chair.
Now exit left and then immediately turn.
Thank you very much, Honorable Ndamase. When this matter comes back, please remember your comments and then help to guide the committee. We will note your comment. Thank you very much. This matter is now closed. Can we get the reflection of the agenda back again? The Secretary? Shireen, are you still available? Okay. Thank you, honorable
Sorry,
members.
Chair.
We have dealt with the first issue. Now, please take us through the second item. There's certainly a problem with your gadget, Shireen. We can't hear you.
Apologies, Chairperson. We have the program for the oversight. The dates for the oversight is from the 7th to the 11th of October. We will be visiting the eThekwini as well as the Msunduzi and the Ugu district municipalities. Sorry, there is the program for the oversight. We will have members traveling on Monday, the 7th of October. We are aware that it's constituency days on Monday, so we are trying to make travel time at 4 o'clock in the afternoon. And then on Tuesday, we will have an engagement at the eThekwini Metro. The engagement will be, we will ask the province, the Department of Cooperative Governance, as well as Provincial Treasury, to brief the committee on the state of eThekwini. We will receive a briefing from the Office of the Auditor General in KZN to give us the audit outcomes of the municipalities that we'll be visiting. We've asked them to do it a 3-year comparison. We've asked Salga also to make a presentation on the support that they're providing to these municipalities. We also asked that the Department of Cooperative Governance nationally give us a view on the state of the municipality, and then we'll speak to the metro itself. We will ask the metro to make a presentation also on this state, and we would want to get an indication of the reasons for the appointment of the presidential working group and the objectives of the work streams that the presidential group is working on. Then we'll do site visits. We haven't identified which treatment plants we will be going to, but if members have information and if there is specific sites that members want us to visit, they can indicate so that we can inform the municipality. And then we have a community or stakeholder engagement. As members can see, this will be happening late in the evening, so to give members of the community a chance to also attend these meetings for people that is working. And then we'll do the same at the Msunduzi local municipality. And then with the Ugu district municipality, we'll do a follow-up on the recommendations of the ad hoc committee on flood disasters, where they recommended that Ugu district must look at accessible drinking water to the community. And then on the Friday, we'll do a deep briefing. Thank you, Chairperson.
Thank you, honorable members. May I, at this point, release the deputy ministers and the department that they would be free to leave the meeting, because the issues that would have needed their direct interventions have been exhausted. At this point, we are on to committee-specific matters, and so the members may not do not need to stay on. Most of the issues that are on the agenda will now need only the attention of the committee members. Thank you very much, Honorable Deputy Minister Ngamashe and Masemula, and DG Dipofa and your entire departmental team. We also excuse the parliamentary legal support team and the public participation team. Thanks for your input. At this point, we would like you to be excused so that we can continue with just direct committee matters at this point. Thank you so much. let's then proceed. We now start comments on the program. Honorable Reddy.
I'm sure Honorable Mkhalip is worried that I'm
Thank you, Chair. Thank you, Chair.
What are you saying, Honorable Deputy Minister?
I'm saying thank you very much. I'm sure Honorable Mkhalip is worried that I'm logging out.
I think the two of you need a bilateral meeting, whether it's an inter-party meeting or a bilateral, I'm not so sure. But thank you very much, Deputy Minister. You shall be logged out. If there's any complaint from Honorable Mkhalip, it will come to the chair. Thank you so much. Honorable Reddy.
Thank you very much, Honorable Chairperson. I'm very concerned about Honorable Kalepi and the Deputy Minister and what's going on there. I think we'll have to do some interventions, serious interventions.
Don't get involved. Don't get involved.
But on a more serious note, Chair, I am concerned about how we handle these oversight visits, particularly with the three identified municipalities, Ugu, eThekwini, and Msunduzi. These municipalities have been plagued with issues of management. They've got management issues. I do not want us to go there and look at water issues and particular issues. It's about governance. There is a lack of governance, and I think we need to approach this at a strategic level. Remember, I know for a fact that all spheres of government have been involved here. I know in Ugu, there was a meeting between national, provincial, local, the local communities. It was a hot potato. There were unrest, the protests in the area, and a host of things around water tankers, water issues, and all of that. So it's important that when we do go there, we make it known that we're looking at issues identified in the AG's report around municipalities and the capacity they have. I think we need to look at things like the qualification skills, whether they have, the officials that have the relevant qualifications and skills to manage their portfolios. Also, to look at the resources that they have and whether these resources are being managed effectively. In some of these instances, you'll find that there's political infighting, especially within the ruling party. It's not about opposition parties, it's interfighting within the ruling party. And this is what is creating political instability. So it might be an opportunity for us to also call on the provincial government, as well as other local government, like for example, Salga, if they could send representatives over, so that when we do go out there and do these oversight visits, we are all singing from the same hymn book, that we don't come and make recommendations that the others might feel, but they were not part of this sort of thing. And I think we must look at this cooperative type of approach, where we work together with other spheres of government in whatever interventions need to be done there. I can tell you this much. Just going there alone as COCTA Portfolio Committee and just to do an oversight, there will be repercussions, I can assure you. People will say there's these national big guns coming down here to tell us what to do, as if we don't know what we're doing and things like that. I've seen this happening before. So my advice, Chair, I say it humbly, you can take it or leave it, but I would suggest that we engage with other spheres, including the provincial government, and as well as organized local government like Salga, to also attend. Another stakeholder will be the water board, the Umgeni Tugela Water Board. Let's also extend an invitation to one or two members of the board, as well as the chief executive, to also accompany us, so that when we're looking at possible interventions, we are able to access resources from other institutions as well. Thank you, my chairperson.
Thank you very much, Honorable Reddy. I note that you are not present in the meetings where we discussed with Salga we've already made an agreement as a committee that they will be part of submitting the reports about the municipality, that they will also be part of the visit as a partner, using their background information and research. And so they actually are a standing partner in the visit. Secondly, we have agreed that the approach will obviously involve the provincial government in the process, the provincial department, and that the issues you are raising were a whole range of issues that we said need to be taken into account. Issues of governance in relation to the political relationship, party, inter-party, intra-party coalition. We want to look at that. Issues of administration, the qualifications of the senior officials, the financial management issues, the AG report, issues of revenue, expenditure, available resources, and all of that. We've agreed that that will be part of the issues that we're going to deal with. And then we would then move from there to deal with issues of infrastructure, looking at backlogs, gaps, what needed to have been dealt with, and also on issues of maintenance thereof and adequacy thereof, particularly then as they impact on service delivery. And then on service delivery, water, sanitation, housing issues, we need to have a sense of all of those. And then the issues of poverty, as well as dealing with unemployment, the community works program and other programs associated, issues of indigent register and provision of free basic services and all of these. So there's a whole menu of issues. And then, of course, the issues around disaster, the response to disaster management issues. Now, so most of what you have said has actually been covered in the approach of the committee. So if we may just give you a sense of that. The question which has not come out quite clear from the report here is at which point we engage with the political leadership, the councillors, to understand particularly the issues of impact of Hang municipality and also issues of interference and political interference. In the outline of how we're going to do this, we didn't mention it in the report. It may not be as clear. So I'm just wanting you to add add your points on this matter. Honorable Van Zyl, you are next.
Sorry, Chair, just a follow-up, please, if I may.
No, wait.
Sorry, I have to get out of my house, Honorable Visman.
No, wait, Honorable Reddy. We've asked that we must do follow-ups after, so let's allow the other members. I'll come back to you. Honorable Van Zyl.
Thank you, Chair. Mine is very quick, actually. On the fourth term program, we've got BRRRs scheduled from the 8th to the 18th. And I'm just worried that our BRRR might fall within that time. So maybe just for you, Chairperson, to liaise with the programming committee on that. Thank you.
Apologies, Chairperson, if I can come in there. The BRRR on the program is for the committees to deal with the BRRR process. So the process in the National Assembly will only start after the 18th of October. Thank you, members.
Okay, you'll just guide us there so that we don't miss out on what's happening. But thanks for pointing that out. Honorable Mkhalipi.
Now, thanks, Chair. Just to remind members, as the son of the committee is stipulating, we are on recess on the 20th from the 23rd, and we are coming back around the 18th. So there'll be nothing in terms of the parliament, in terms of the program. But I want to check, Chair. I have a serious network problem. I couldn't hear the whole program presented by Committee Secretary Shefrin. But I heard saying that the AG is going to do the presentation. But my understanding is to align myself with a member, and you also corrected him, saying that when we discuss the issue of visiting Ethekwini,
SALGA was invited as well. But in terms of putting the program to be very clear, Chair, my understanding is that we must be welcomed by the MEC of Khoisan in the province to give us the clear picture, the perspective of the province. Then we zoom into the oversight that is specific. But when we arrive in the province, on the day we arrive in the meeting, the first person to brief the committee is the MEC, who's going to take us on what is happening in the province per se. And then the department will follow afterwards. The province has given a picture in order for us as a committee to understand what the province is telling us. Is it a true reflection of what is the understanding with the then we must get down here as per the program of the committee to say, as we are here, the oversight will be done on two municipalities, which is Sunduzi and Etegwe. I just wanted to check one, Chairperson, whereby the AG will come and SALGA and everyone. But the first step is to get a proper report from the MEC on behalf of the province, Chair.
Thank you. The MEC part, we had agreed earlier when we spoke about it, and I think it's appropriate. The SALGA, we actually asked them to be part of the visit, and we asked them to share their information with us. The AG's report, my understanding was that we were going to use the AG's report as background information, but we did not anticipate that we'll have a new presentation from the AG's office, but it will be at the pleasure of the committee whether we do that. We also inviting them to be part of that would still be appropriate. The question of whether they will do a presentation is something that I think the committee can guide. But your comment about getting welcomed by the MEC is going to be important, and also the flow of these activities is also important, because if it's MEC, and then after that we need to get the municipalities to table their issues, we then need to make sure that we hear from the presidential committee, but we also need to at some point get a sense of the councillors, whether this is EXCO or the full, I wouldn't know, but it would be good to get that, because the issue around political interference and the issues of tensions, inter-party and coalition and all of that will come out a lot more when we get to that kind of discussion. So I think let's pull the issues together. What I wouldn't rule out is the issue of the visit to a concrete infrastructure project, even if it's a very brief visit, because the issues of water and wastewater treatment in Etegwini have been a huge issue as well. So let's try and clean it up, but we note your comment and we will accept that into the program. It needs to be restructured a little bit. Thank you very much, Honorable Mkhaliphi. Honorable Lapus Kakhne.
Thank you very much, Chair. I just need a little bit more clarity on the community engagement. How do we envisage that is going to be, and what are we going to, because we're creating expectation from the community that we are going to listen to them, which is what we're going to do. And but also, what are we going to do with the information that they're going to give us? Because we have a specific program that we are focusing on. They may have a lot of things that's part of our program, but they also may have a lot of things that's not part of our program. How are we going to engage or to manage that? Thank you.
If I may ask you, what would be your proposal there? Would you suggest we skip it so that the members can comment on a concrete program?
Chair, I'm not so sure that I would suggest to skip it, because there must have been a good reason that we put that in the program. I'm just very concerned about the fact that we create an opportunity for people to talk, and then we also may have created a expectation for a feedback session on that. which this committee cannot undertake to do, or we have to undertake and say, if we have a meeting, we have to give the guidelines and say these are the things that we are looking at, and we want to get your information on that, and we undertake to give you feedback through a report or whatever. But just to have a meeting with community, with people, they rock up there, they make the effort. It's a lot of time that we spend there, and then not to give feedback or have a way of letting the people know that we've listened to them might come back and bite us.
Okay, thank you very much. Honorable Khalipa, I'm not sure it's your repeat request there, but let me help have Honorable Reddy. And Honorable Shenge, please mute your mic. Honorable Reddy. Honorable Reddy wanted a follow-up. If you've dropped that, that's fine.
Thank you, Chair. I'm here. Don't go away. So this device and all this issue. Honorable Chairperson, I want us to look at these things differently. Let's not approach these visits like the way it was done previously, because remember, I'm coming from the other side now, where I was a councillor, and I know how we saw these visits by national members of parliament. We just saw it as just another sort of, dress up well event. I feel that it needs to be more impactful. And the way to do it is, let's look at things like the Chamber of Business, inviting the Chamber of Business, inviting the media, inviting key business within the area. Like I know, for example, the Ugu area, you've got SAPI there. In eThekwini, you've got Toyota that's trying to do work in eThekwini. Then you go to Msunduzi. There's big business in Msunduzi that's also that wants to contribute and wants to assist and come up with also good ideas, etc. The unions, nothing is stopping us from going with a sort of a team that's all encompassing, that has all sectors, and together we go out there and try to find, apart from identifying problems, but also go with solutions that can come from other key stakeholders. So I don't think it's too much to ask for too late, but I think we've got about a week in which, even if we have to send them invitations, requesting them to join us as the chairperson of the committee to join us in these visits, I think it will have a bit of a greater impact, Chair. Thank you.
Okay, you're making me a little concerned about if there are challenges in governance in eThekwini. The president has gone in there, the minister has gone in there, the MEC has gone in there, and the committee wants to understand what the impact of all of this. And of course, the councillors are not happy about anybody following on them. To what extent should that be the basis on which we decide will we go to Maluti Apofung and the councillors are not happy that we come there? Will we go to Matlosana? The councillors don't want anybody following them up on what is going on there, or in Tshwane and so on. So having got that experience of having been in the municipality as a councillor and knowing how they resent anybody following them up, and yet the public has got issues, to what extent do we consider that instead and not balance with what is our responsibility to the community? And I'm throwing that back at you because I'm saying, look at it from both sides now that you've got that experience and this responsibility. So we can talk about what we need here is a kind of framework that will help us to come back with a sense of what the issues that have plagued municipalities. One, we have been able to understand them better. Two, we're able to get the focus placed on what needs to be done and corrected and where accountability needs to go, so that we can say, sitting as Parliament, we have performed, we have discharged our duty of oversight over the particular community, over the particular municipalities. This is the first of the few. There'll be many more that we need to do. Obviously, we'll refine as we go. So let's try and refine this. We need these ideas, but I also don't think we should approach them with a fear that someone might be disapproving simply because they think there's too much attention, they're an independent sphere, and all of that. Part of our responsibility is to be able to bridge just that gap. Honorable Buthelezi, Shenge.
Thank you, Honorable Chair. Kabazela, thank you. And in the interest of time and everyone present. Chair, I mean, if I may just ask a question to help my understanding, because of course, bearing in mind that I'm a new member, I just want to understand that what criteria is used to choosing the topics or the areas that we need to cover when we go for this public participation. I'm sure there is some science to it, and secondly, we've seen this many times, that there'll be a time where in your own wisdom, you will choose these areas, and of course there's a reason to choose them. You get to that public interface, and they stray way far away from what you thought we had come to cover, because probably they think that those issues they are raising are more important, number one, and number two, they see that maybe in desperation that now that there's this high-ranking committee there, it will help to help them being heard, especially on issues where they've not been heard. But maybe, Chair, I just want to understand, because I've seen that many times that you get to this interfaces and this interface, and they just really put very little emphasis on what you've come for. But of course, it is because they have more burning issues. How do you control that? Because at the same time, you can't say, no, this is what we have come for here. And never mind that. Thank you, Chair.
Thank you very much, Honorable Shenge. What guides us as a committee, there were presentations that were given to us at the beginning of the term where we're going through orientation. And one of those was what we called dysfunctional municipalities or municipalities in distress. And in the course of that, there were certain reports that we were picking up either in the media or from the AG or from the discussions with the minister that made us feel that we need to visit some of the municipalities where there are certain areas of concern that have been raised. Now, the nature of the issues that I've highlighted, when I said issues of governance, what we're looking at, political, administrative, financial management, service delivery, and so on, those issues were at the core of what came from the presentation on dysfunctional municipalities on the one side. On the other side, they were almost aligned with what came from the Auditor General's report. So that's what generally guides us. Now, there are many municipalities which are affected, and for various reasons, some of them have actually been coming up in public or in the reports that we have actually looked at. That's why I mentioned a few of them. The list is much longer, and I don't think we'll ever get through to all of them. So that was generally what tends to guide us on this matter. So that's one aspect. So the items are actually basically guided by what has come out in the previous meetings in terms of what are the concerns around the dysfunctionality of municipalities and AG's report and so on. So that's one aspect. The second aspect relates to the communities. Now, part of what is a balance which we need to try and hold ourselves is the fact that if there is any oversight visit that we have to carry into a particular area, is it correct for us to simply sit in the office and talk to the municipal officials, or do we need to actually, in a way, get a feel of what the community's concerns are? Now, how do you balance the issues in relation to communities where communities have got a whole range of issues that they are interested in on the one side, and on the other hand, there's also a sense of us having to make a point for the communities that we are here to represent their views, and we're trying to work together to improve on service delivery. So there's a balance that some of the members have raised here, which we need to reflect a bit on. But the need for us to visit communities arises from the fact that most of these municipalities where there have been the service delivery issues have had communities exploding into public protests, and partly because there's a sense that the only way they can be understood or heard is when they go onto a violent protest, when in fact the parliamentary process is another avenue for reflecting on their requests and concerns, so that the process can be activated for them not to need to go into public violent protests, as it were. It's difficult to cover everyone, as it were, but to go into an area and have no reflection on what communities have to say is a bit tricky. Now, for example, in this case, we had the members here saying, how do we deal with issues that come from the constituencies? And we said we'll table them and find space to discuss them and see how we can intervene, even on individual issues, to try and get the system to be more responsive, as it were. So it's something that we will never get right, but we certainly need to find a way of how do we refine it as we move along. Because in some of the instances, there would be individuals or there would be communities that would raise issues, but somewhere along the line, if Parliament is there, can you really walk into a municipality and not even try to listen to anyone of the public concerns and just walk away on the basis that they might come and raise so many wide issues? So this is where I think we need our all collective guidance amongst ourselves. Now, having said so, I see we still have, because on this one, there's not one person who's going to have the monopoly of wisdom. We just need to have a consensus of understanding on our approach. That's how we're going to reshape this. At the end, if the members feel we must drop this, then we must drop it. And if members feel we can do this, but amend it here and there, that's what we need to do. Honorable Sols? I've still got Honorable Mkhaliphi and Honorable Labuskaghni on the platform. If they need to comment again, I'll come back to you. Honorable Sols?
Thank you, Chair. Just a matter of interest, seeing that the oversight is in the Durban area or KZN area. We've received some complaints around, I think it's the Mandini municipality. I've obviously not been there, not really familiar, but we've received some complaints of land grabbing there, people selling off land, private land. I'm not sure if we would be able to somehow bring attention to that or seek to address it or inquire about it. Thank you, Chair.
Okay, that is a bit more specific to a community. The best way to deal with it would be to guide them into taking the matter to the relevant department, and maybe depending on where this is taking place, we might just need to look at the specifics and guide each other there. But at the end of it, land grabbing issue is a matter of the municipality having to act on its own, in which case we might need to reach out to the municipality, or alternatively, it might then be, depending on what is the nature of the issue, might need that we get to the land affairs aspect. But mostly municipalities tend to have a way of responding to those issues because it happens as part of the settlement processes of of the particular municipality. Most of the municipalities have even got units that prevent land invasion. So it will just need to be cleaned up first before we can actually refer to it. But in relation to this particular program, it may not be as easy to bring that into it because neither of these areas are part of where would be going, except if those members might take advantage of your proximity and then come and give you more update on that. Then you can feed us back as a committee as to what you're finding. But ultimately, the municipality has to be approached to address the issue because it's normally a land invasion for housing that tends to be the problem there. But without knowing any more details, I wouldn't be able to see how best we can deal with it. I think what we need at this point here would probably, there are a few consensus issues. Honorable Mkhalipa, are you still on there? But
Yes, Chair.
yeah, please come in.
Yes, Chair. I wanted to emphasize on the point that you raised regards to eThekwini, that when we visited the community, as one member was asking, how do you identify a community? So if you can tie it up into the issues that are problematic within eThekwini, one of them is water. And member raised the issue of Umgeni that must be invited as well. You raised the issue that we must also invite councillors. It's either the ESCO, or I will suggest that yes, if you can invite the ESCO because it's a multi-party ESCO, I believe. And because we need to zoom in on the issue of the water, instead of going to a particular community, ask eThekwini Department of Water and Umgeni to go and visit one of the reservoir that is also seems as if it's a problem in terms of giving the community water. Maybe if we can tighten it up around the water issue, and I think the community will be very happy in order to get into a bottom of a problem of, is it a water bill or is water in general? Because there is also a very huge crisis of water, I think since 3 years ago, and the issue of new tankers that has been brought to the under eThekwini instead of water from the standpipes. So the one that he was raising in terms of calling the media, I think we have covered very well, Chair. We must not seem as if we are not sure about our constitutional mandate as the committee to go and do the oversight. And also to emphasize on the point that whether the councillors are saying that, no, these people, they think they are better, that's why they are here, nothing will happen. No, we have mechanisms whereby the mayor is an accounting, as a political head of municipality, come and account on time to time and update on the issues that we raised during the visit. So there's no way that we can go to oversight and then we left it open like that, as if we don't have mechanisms as this portfolio committee under this parliament. So the mayor will come and update on the issues. We are going to make follow-up in terms of the issues that we went and do the oversight in Msunduzi and eThekwini. So instead of going to the business community, maybe what we can do, Chair, as we have discussed a matter before, but it's not under eThekwini, it's not under Msunduzi, but it's the matter that is under King Cetshwayo or Richards Bay, that issue that combine the community and the business people in the area regards to that issue of mines. So if we have time, we can do that in order to address the issue of business stroke community instead of saying, let us invite the business. We must guide against of being captured by the business in terms of the committee. While we assist to do is to ensure that the community members are well represented, they have a voice through this committee. I think we have covered very well when Babu Shenga was asking, how do you prioritize topics? I think you said it at all, Chair, how do you manage to navigate, because our problems are too many in the committee. Thanks, Chair. Those are the things that I wanted to add. Thanks, Chair.
Thank you very much. Honorable Sauls, are you still back? Is it the legacy hand?
It's a legacy hand, sorry, Chair.
Okay. All right. I think let's try and resolve a few of the issues so that we've got better guidance. I think your comments all are very helpful. The starting point, and I'd like the committee, the secretary to try and structure this thing properly. So the approach that we're taking, one, is that we are going to have an inclusive delegation that will have between us and SALGA joining us in this regard. So they'll come with us, but they'll also share information with us ahead of the time. Secondly, that we will use the AG's report, but also we could inform the AG that we will be attending, we will be visiting in case they might wish to join us, not necessarily for a whole presentation, but for the discussions, if we're going to have to get to discussions, and they could then be present there. But that is on the basis of our engagement with the AG's office in relation to these particular municipalities. Thirdly, that we need to then inform the MEC that we are visiting these particular municipalities, and would like him to join us at least on the first day on the presentation of the situation in the province. But in particular, we're looking at these particular municipalities, and that we at the moment will target eThekwini, and then Msunduzi, and then Ugu, mainly as to get a feedback on the last visit. And with these two municipalities, we're going to look at the issues of governance, but in particular, when it comes to the issues of service delivery, the areas we identified, one was the issue of water. And so let's take the suggestion by Honorable Mkhaliphi. The communities that are affected by water, where there's a real crisis with water, let's deal with those, and particularly go and view the water programs in the areas where those communities are. Largely, we are dealing with big communities here where there are those problems. But in the process, also would like to invite those water services boards to also share with us what is their program to address the problems of water in the particular communities. So if we meet communities in those areas and we indicate that we are here largely about issues of governance into the municipality, and in this particular community we are looking at the issue of water, and also that will also deal with the issues of the water tanks, as it were, and then that of course we could just focus on those. Communities will raise other issues. We can't restrict that, but that becomes the issue. But the other issues that we want to get for the municipalities will be issues, whilst we're at it, community works program, whilst we're at it, issues of indigenous policy, and in terms of how we're dealing with the response to our challenges of the poverty as it affects communities, and the high cost of the high cost of living for the communities. And indigenous policy is one of those that is a response of government at that level. So that basically will deal with the issues. Now, in relation to meeting with the MEC, then the MEC takes us through the particular issues. But secondly, we then should be able to meet with the EXCO to have a quick sense of how the governance from the political perspective, particularly the issues of political interference and challenges of coalitions comes up. Then, of course, we've got the issues of the interventions. In eThekwini, there's a presidential team, and then there's administration, the issues of the qualifications that we spoke about, the issues of the Auditor General's report, and all of that comes in at that kind of level. And then, of course, in the process, they should also be able to address to us their approach to infrastructure, their approach to the issues of service delivery. That should more or less cover what we have a responsibility of oversight on. It would then have included background information from SALGA, from AG's office, and from the Department of COCTA. At a certain point, we even wanted to approach the Department of Monitoring and Evaluation if they've got any information in relation to these municipalities, it might be helpful. So as we go forward, we just keep to the same framework and vary it here and there depending on what the issues are. It will help us to have a structured standard approach as well as standard report, and then at least we also don't be all over, except here and there where there are different emphases. Now, the issue in relation to involving business and so on, Honorable Reddy is making that suggestion. I think, like Honorable Mkhaliphi, I don't know that we can have a coherent approach to talk to business in relation to their role in the creation of employment. I think it might tend to be a bit wide as a subject to deal with that. So I'm not so sure we can handle it. And so we have to think a little bit about that. But I think before we can finalize and refine how we're going to deal with this issue, I think we need to avoid going to that one, because again, we'll be raising expectations on issues of which we may not have a lot of background, unlike the issues of service delivery and governance and concerns of communities. I think there we're fairly stable in terms of what we need to discuss with the communities and with the municipality. The issue that Honorable Mkhaliphi is raising about King Cetshwayo, between myself and Honorable Mkhaliphi, we're going to try and refine that issue, because like what Honorable Sauls has raised, there are issues that have come from communities quite serious, but which we need to find ways of how we can address them. The one that Honorable Mkhaliphi is talking about is an issue of Gwambonambi, Richards Bay area, where there is a community that is in serious conflict involving the traditional leadership conflicts. And the underlying issue there is the issue of mineral rights and the relationship between the community members and the relationship between the community structures and the mining company and the general criminality that's arising or underlying conflict that's in there. So we would need to brief the committee a little bit better before we can move on. We will see whether the program allows us space to be able to give attention to that issue. So I think for now, let's not say too much about it until we know whether we can find a way to incorporate it into this one. But I'm giving this outline as a kind of consensus of areas where we can at least be settled with our approach. Then we don't have a lot of disagreements about what we're trying to do. It does address the matter of Honorable Lapus Kakhne, that when it comes to the challenge of water, we can approach a community on the basis of which we would then be discussing the issue of water, just to understand it and also to see what the municipality is doing about it. The fact that the municipality, that the community will raise issues about the hall, about the clinic, about corruption and so on, are issues that we may not be able to avoid, because then they've only got one chance to meet with the committee, so they'll raise some of the issues, some of which you might be able to refer for addressing, others that we might need to see how we handle at that point. But I wouldn't like us to fear going to talk to people on the basis that we're not the ones who are running the executive of that municipality to address them. So I think we need to find a way. But having said so, I think we also need to be guided by the areas where we think the issues of water provision can be exemplified by such a visit. And so, yeah, the point again, which I would say to Honorable Reddy, look, I don't think we must be too worried that the councillors will say, why did you come here? You think we are better. The minister was there and the president was there. Parliament has to also be there. But there are problems. So whether councillors like it or not, there are problems that are attracting attention. And so at a certain point, our view has to be about how best do we conduct this thing so that it is clear, it is in the interest of accountability and good governance, and it's not about individuals as to who thinks they're better than who. And that, unfortunately, we're going to visit different municipalities as part of our oversight. Everywhere the councillors might have the same attitude. Maybe it's our responsibility to also help them to change their attitude, to say, no, you are not going to prescribe whether the parliamentary portfolio committee oversight program should involve going to municipalities. Otherwise, what's the point of sitting in the parliament and never actually get out to see, in real how things are on the ground? So that would still be my issue. We can still continue to engage Honorable Reddy even outside this situation, seeing that you have just come from that environment. But I think it's something that we need to find a way to overcome. Having said so, colleagues, I think that outline for now gives us a general sense of consensus on approach. If there's anything left out, we could then talk about it. But I think this framework may be useful as we go to other areas as well. So it was worth us investing a bit more thoughts in terms of how to approach it. And certainly we need to then generate the letters that go to the MEC and informing them, and maybe with the Premier informed, but we mainly need the MEC to be with us on this. And so I hope that this approach, that summary helps us to get some general consensus on the approach. If there's anything left out, members can indicate. But at this point, I'd like us to close this and move to the next item. Any other comments? Are we fine with it?
We fine, Chair.
Thank you. Thank you very much. Let's move on. Let's look at the next item on the agenda. And please, let's do that on considering that it's lunchtime now. Please, Sherin, let's put the next item. We're having Shirin, are you still there? Okay.
Sorry, Chairperson. This is the one thing that wasn't on our agenda, but we did send the report yesterday.
Just hold on. Just hold on. What are you saying? Where show us the agenda? No, first show us the agenda. Okay. Look, on the agenda, we have the committee resolution register for next term. Now, when we started, Honorable Van Zyl was concerned about the volume of information that comes in a bit late to the committee. Now, can I just get a sense whether the committee believe that we can talk about this issue? Should we defer it to the next committee meeting? Just flash the outline of this resolutions register. So just for members to have a sense, if you have had time to apply your mind on it. If not, we'll have to refer it to the next committee meeting. Just show us the register. Colleagues, this is what is being proposed for us as a register of the resolutions to reflect on. Do the members believe that they've had adequate time to apply their mind on it, or do you like us to defer it? Honorable Van Zyl?
Thank you, Chairperson. It was a comment in general. I'm not talking only about today. I'm saying that, we shouldn't be getting any documentation with less than 24 hours to go. So it's in general for you to step up and step in and say, look, we can't have members with less than 24 hours to go into these things. So, I mean, the resolution register is quite needed, obviously, because we need to know what's going on. And so is the constituency issues. But I wouldn't mind, as we are going and having to travel to plenaries now at 2 o'clock. This meeting was only scheduled until 1. If we could defer those for the next meeting. Thank you.
Proposal for deferral. Do we have that supported?
Support, Chairperson.
Supported. Anyone objecting so that we can defer the subsequent issues to the next meeting?
No, I'm not opposing, Chair, but I want to add to say that since some of the issues are emanating from the community, and community are expecting responses as soon as possible. If some of the issues, while they're still going to be engaged here in the committee, if they can be sent to a PLO and be directed where it's supposed to go, if it needs the attention of the minister or the department and so on, it must be do that instead of waiting until we engage in the committee, Chair. That is my proposal.
Your proposal is supported, and we've tried to do that in the past on other issues where the matters need to be referred for action. So when we get to the committee, we'll talk about what we've done with the issue. So that I think helps in the process. So firstly, let's agree now that the subsequent issues will all be deferred to the next meeting. That's the first issue. The second issue is that the issues which have got concerns of the constituency that are brought to our attention that need a further referral will be referred to the relevant department for action, even if they will be tabled for discussion. And when they are tabled, they will have a note to say that the matter has been referred to the minister or to the department or whoever, so that it is clear that the matter was not going to lie there until we have a meeting to discuss. But for us to discuss them, it's important, but the referral will have to happen. The third one is the point raised by Honorable Van Zyl that let us endeavor to circulate information long ahead of time so that we don't overload members with work within 24 hours of having to sit in a committee meeting. That, with those three comments, that should guide us as we move forward. With that, therefore, all those matters will be deferred. All those matters will be circulated ahead of time so that they are not overloading the members. And with that, the member matters that come from the constituency will still find their way to the committee, but they will have been acted upon and be referred to the necessary referral office ahead of time. With that, then, therefore, we would then halt the meeting at this point. If there's any other issue members want to raise before we close the meeting, please raise your point now so that we can then close the meeting and allow members to prepare for the session. There being no other matters, then at this point, I'd like to adjourn this meeting. We will then be informed of the next meeting. Certainly, we still have challenges with Wednesday. So for tomorrow, there will be no meeting of the committee. and then we will then be informing each other of the next one. Honorable Mkhalipi?
Not to be discussed now, Chair, but to be packed in your program to give guidance is the issue of the study tour, as we have briefly raised it before, Chair. Maybe look at it, and then in the next meeting we can also reflect on it. Thanks, Chair.
Okay, thank you very much. That matter will be put on the agenda so that we can reflect on it. Thank you very much. And therefore, that also leaves me the opportunity to thank all the members for attending. And once again, congratulations to Honorable Mkhalipi for being awarded the degree on the Masters at Law by the University of KwaZulu-Natal. Congratulations, and certainly we will be with you in spirit, and hope when you're done, you'll come back with the cake for the committee to enjoy the celebration with you. Thank you very much, members.
Not the committee that will be also having a cake for me.
Congratulations.
All right.
Thanks very much,
Members,
colleagues. Thanks very much, Chair.
Yes, yeah, we'll take a committee resolution about the cake when we meet next time. Members, this meeting is adjourned. Thank you very much. Please enjoy the rest of the day. Bye-bye.
Thanks, Chair. Thanks. Bye, colleagues.
Thank you, Chair.
Thank you. Thank you. Bye.
Thank you. Bye-bye.
Thank you, Chair. Bye-bye.
Thank you. Thank you so